Uh, can anyone on the stream hear me now?
Yes, I can hear you.
Okay, wonderful. It sounds like we actually have things working for the moment.
Great, thank you.
And who am I talking to?
This is Ahmed Faruqi with the Bradley Group.
Good morning, Dr. Faruqi.
My pleasure. Good morning to you as well. I assume it'll be audio only, or is it also video and audio for me?
It is audio only, and you're broadcasting into the hearing room right now.
Okay, got you. Well, I dressed up, but I guess I'll relax.
That's right.
Okay.
Okay. Well, let's go ahead and get started then. Dr. Faruqi, we'll come back to you in a moment here, but so you can just stand aside for the moment. And let's go ahead and get started. We're on the record at this point, and this is file number ER-2021-0240, and also file number GR-2021-241, which involves the Ameren Union Electric Company doing business as Ameren Missouri's tariffs to adjust its revenues for electric service and natural gas service. For the most part, the gas case, or actually for entirety, the gas case has been settled. We will only be dealing with the gas side of this to put in exhibits at the end of the the process today. So we're going to start today by going, and the exhibit numbers have already been assigned. We'll go ahead and get started with opening statements then, beginning with Ameren, Missouri. Yes. And I will add, the court reporters asked me to make sure you speak up when you have your mask on so that you can be heard.
Understood. Thank you. Good morning. The parties to this electric rate case have entered into two stipulations and agreements that resolve the vast majority of issues in this case. So that only issue number 17A, which relates to the potential renaming of the company's TOU rate plan, and only portions of what has been identified as issue 22, class cost of service, revenue allocation, and rate design remain for this electric rate case. So let's focus first on issue 17A, the renaming of the residential time of use rate. The timing of staff's recommendation for renaming is terrible. To use a nautical metaphor, the naming ship has sailed. It's important, though, to understand some historical context here. The EV Savers and Smart Savers rate plans, among others, were approved through a settlement in the company's last electric rate case, which was file number ER-2021-0335. No party stated an issue with implementing the Smart Savers rate name in that case. The only naming question that was raised was a concern about using the acronym EV for electric vehicles for one rate offering, which the company had called the EV Savers rate. And the company agreed to remove the EV from that rate name to avoid potential confusion that customers could assume that only customers with an electric vehicle should be on or possibly would benefit from the rate. So following conclusion of the last electric rate case, which was only a little over a year and a half ago, the company conducted extensive customer research, which included focus groups and surveys with diverse customer segments and geographies to develop a communication strategy. And in accordance with the stipulation from the last electric rate case, the company met repeatedly with stakeholders to discuss its automated metering infrastructure, AMI, meter rollout, and the TOU customer education and communications program, and even presented at a commission agenda explaining our communications plan. And again, no concern was expressed about the Savers naming convention under the company's plan through those meetings and discussions. And highly regarded rate design expert, Dr. Faruqi, testified in rebuttal, quote, Ameren Missouri has done as much as any utility can do to intrigue customers with the concept of time variation in rates, to draw them to its website, and to educate them on how best to reduce their bills on the new rates. The toolbox of this customer education plan includes a web page dedicated to TOU rate options, multiple mailed communication pieces to customers, a bill comparison tool, there's an educational video for customers, and we provide some specialized training to company employees who then assist customers with TOU rate name and rate plan questions. All the items in that toolbox would have to be revised if the names of the two OU rate plans were changed. And those revisions could not be completed overnight. As the commission is aware, the company actually received permission to delay portions of its TOU communications and education plan, specifically the bill comparison tool and implementation of certain new rates. And that was in file number ER-2021-0240. So the broad rollout of the TOU program began in May of this year, with customers first being transitioned to the new default time of use rate around the beginning of June. As Ameren Missouri witness Stephen Wills explained in his rebuttal testimony, as of November 1st, so just the beginning of last month, over 170,000 residential customers were on the evening morning favorite rate, that new default TOU rate. And 461 were on one of the advanced rates, which would either be overnight savers, smart savers, or ultimate savers. So hundreds of thousands of customers have sailed through the TOU customer education and communication journey. And now staff seeks to have the names changed that have been used throughout that journey after the naming shift has failed. That is a potential recipe for concern for disastrous customer confusion and frustration. So what did staff identify as its basis for recalling this failed naming shift? Any specific customer research they conducted? No. Any actual customer experience? Nope. Rather, staff suggests that the names portray the rate plans as money savings opportunities and don't indicate potential risks of bill increases. But the focus on saving opportunities in the rate plan's name is absolutely appropriate, as the plans unquestionably create savings opportunities, which are already being experienced by early adopters of the advanced TOU rate plan. I mean, that's really the point. These plans were designed to encourage customers to take action in response to price signals, to shift load, thereby providing benefits to the system, and then subsequently save those customers that took some action some money on their bill. Dr. Faruqi explains in his rebuttal testimony that the notion of saving money on their electric bills is key to customers being willing to undertake that required behavior modification to experience savings. But the company is not stopping there. It's also arming its customers with information to empower them to make those choices about these rates with eyes wide open, about the effect that these rate structures will have on them based on their lifestyle, based on their usage characteristics, through that customer-facing bill comparison tool. So not only has the naming shift failed, but there is no reasonable basis for potentially causing a storm of customer confusion while customers are still on their TOU voyage by renaming the TOU rate plan. So if I could shift now to revised issue number 22, which is again the class cost of service, revenue allocation, and non-residential rate design issues. Start first with the class cost of service. Now, of course, class cost of service studies are merely a starting point for revenue allocation and rate design. Such studies are a tool for designing rates so that cost responsibility is equitably, not precisely, but equitably allocated to each customer rate class. Company witness Thomas Hickman, has direct testimony and schedules that presents the company's class cost of service study. And within a class cost of service study, there are many different categories of costs to be allocated, and only 3 of those categories are at issue still for hearing. So sub-issue 22A focuses on production costs, so generally the investment in the generation plant and the expense of operating them. 22B then focuses on non-fuel, non-labor components of production, operation, and maintenance expense, or O&M expense. And 22H focuses on distribution costs, generally that cost of the company's distribution system and associated expenses. So Ameren, Missouri continues to support its classification and allocation of all costs as presented in its class cost of service study, as set forth in Thomas Hickman's direct testimony and schedule. So more specifically, the 22A, production costs generally are allocated using the 4 non-coincident peak, or NCP, version of the average and excess, or A and E, demand method. Under 22B, for those non-fuel, non-labor production O&M expenses, that's a variable cost. And so we have provided that those should follow the production energy allocation method, so basing it on the megawatt hours required of the generators to provide service to each respective class. So then for 22H, the distribution plan, of course, that includes FERC accounts numbers 360 through 369, and each of those accounts needs to be allocated to then each customer class based on the breakdown of each of those accounts between customer-related and demand-related components, as set forth in Ameren, Missouri's class cost of service study. But again, a class cost of service study is not intended to be a precise tool to strictly be followed when allocating revenue requirement increases nor designing rates. And there are a variety of policy or other factors that may intervene, such as the policy of gradualism and trying to avoid rate shock for customers. Therefore, when it came time for company witness Michael Purdy to propose how that revenue requirement increase should be allocated to customers, which is sub-issue 22C, Ameren, Missouri proposes to use a 2-step process, similar to what it has proposed in the prior electric rate case. So under that, first, the class's current base retail revenue is either increased or decreased on a revenue neutral basis. But that really just resulted here in a small adjustment within the lighting classes, which are the 5M and the 6M classes. So then the second step is that the revenue requirement increase should be allocated to customer classes as an equal % of current base revenue. Now that leaves only 3 rate design points at issue, and those are all related to non-residential customers. So sub-issue 22F relates to NECG's proposed shifts to increase the demand component for the large general service, or LGS, and small primary service, or SPS classes, and correspondingly then decrease their energy charges. The company does not oppose NECG's proposal, does not oppose their proposal directionally, but noted some potential concerns about bill impact to customers within those classes due to the magnitude of the movement that NECG proposes. Also, the company did note the potential diminishment of promoting electrification through their proposal. And then sub-issue 22G relates to MECG's recommendation to require the company to present analyses of alternatives to the current hours used rate design by 2025. The company is very open to evaluating rate design changes for non-residential customer classes. However, we believe that the AMI data, advanced metering infrastructure data, is needed and should be reviewed to develop such alternatives. So the company views this directive to present such alternatives as unnecessary. So that leaves sub-issue 22I relating to rider V credits. And regardless of whose class cost of service study is used, rider V credits should not be suspended. Customers invested in their own substations and should continue to receive the modest credits for doing so. Thank you.
Thank you. Any of the commissioners have questions for Ameren? Okay, I'm not hearing any. So you can step down. Thank you. While Ameren was presenting their opening statement, I realized that I had not taken entries of appearance. I don't know if anybody else was wondering why this crazy judge had not done that, but I just got thrown a little bit by all the technology this morning. So let's go ahead and step back and take entries of appearance, beginning with Ameren, Missouri.
Good morning, Jermaine Grubbs on behalf of Ameren, Missouri.
And Jim Lowry on behalf of Ameren, Missouri.
Okay. And for staff.
Good morning, Judge. Kurt Stokes on behalf of staff. Also with us are...
Yes, Jeff Keeble, also representing staff, Judge.
Thank you. And for public counsel.
Good morning, Mark Poston, the Office of Public Counsel.
For MECG.
Good morning, Your Honor. David Woodsmall for the Midwest Energy Consumers Group.
Thank you. And for MIEC.
Diana Plusha, the law firm Curtis Hines here.
Okay, is anyone here from Legal Services of Eastern Missouri?
Yes, Judge. Paul Bars for Legal Services of Eastern Missouri. Thank you.
Thank you. And for Consumers Counsel?
Good morning. John B. Coughlin, appearing on behalf of the Consumers Council of Missouri.
And the other parties to this case have been excused from participating, so I believe that takes care of everybody. And now we'll move on.
Commissioner Holzman.
Pardon me?
Judge, just Commissioner Holzman, I just want to let you know I'm on as well.
Okay, very good, thank you. And we'll move then to opening statements from staff. If you want to speak from your desk, you can, Mr. Gable.
Oh, went up here.
Okay.
Thank you for the offer, Judge. One thing that occurred to me before I actually start the opening, while I was listening to Ms. Grubb's statement, there was one additional issue late filed. I don't know that you mentioned that. It's not going to shouldn't affect the openings, but I wanted to make sure that that you were aware that there had been a issue that was, I think it was under 22J3 that was initially left off due to the...
I am aware of it,
Okay,
yes.
good enough. Thank you. Excuse me. May it please the commission. From the list of issues, position statements, and what you may hear in the other parties' openings, it would be easy for the commission to conclude that there are some huge issues to decide concerning class cost of service studies and interclass revenue requirement allocation in this case. Fortunately, there are not. Even the Ameren, Missouri class cost of service study, which I may refer to as a CCOS study, if examined on a revenue neutral basis, indicates that all classes other than customer-owned lighting are providing revenues that exceed allocated expenses and are contributing toward rate of return. Staff reviewed the Ameren study on a revenue neutral basis to determine the level of over or under contribution of each class to Ameren, Missouri's revenue requirement as a percent of rate revenue, to determine whether any classes were contributing outside of the plus or minus 5% range staff has typically relied on for recommended revenue neutral shifts to class revenue responsibility. While customer-owned lighting was found to be outside of this threshold, no other class was outside of the range which would trigger a shift recommendation. And I would also point out that of all the parties to the case, only staff in Ameren, Missouri performed standalone class cost of service studies. But you will probably hear a lot of argument that the staff study allocates the cost of building wind farms to the classes as if the total cost of building a wind farm divided by the annual generation that wind farm produces is the cost of generating with wind. And that's right. That's exactly what staff did. What you won't hear the other parties explain is how they allocated the variable cost of generating with wind, because there really isn't any. So the parties who say that staff allocated wind incorrectly allocated wind costs and revenues by saying that all the wind costs should be allocated as capacity, and all the wind revenues should be allocated as energy. In other words, they say that the residential and small general service customers should pay for about 65% of the cost of Ameren, Missouri-only wind farms. But the LPS, SPS, and LGS customers should receive about 45% of the revenue from the wind and about 45% of the renewable energy credits generated by the wind. In other words, excuse me, LPS, SPS, and LGS customers would pay 35% of the cost, but retain 45% of the benefit. You may also hear that staff is on some quest to nail down each piece of wire to the customer that uses that wire. That's not accurate. Every customer has infrastructure that is used to serve only that customer. Obviously, there are meters, but there are also transformers, and there are also the wires, and in some cases, conduit or poles that connect each customer from the main distribution lines. For customers served at secondary voltage, that equipment is known as service drops and line transformers. For primary customers, that equipment is socialized throughout the distribution accounts. Staff study is the only study that attempted to put an estimate on the value of that equipment and allocate those costs to customers who are served at primary, just like the cost of the equipment that operates only at secondary voltage is allocated only to customers who are served at secondary. Now, this brings us to an area where Ameren, Missouri's apparent confusion of staff's position came to light during a deposition it conducted of staff witness Sarah Lange. During the deposition, questioning by Ameren indicated Ameren believed the rate class contained in the staff study labeled direct assign reflected some goal on staff's part to increase the level of rate base that is directly assigned rather than allocated. That's not the case. That rate class is constituted of the special programs Ameren, Missouri has begun to offer, largely community solar, where there are significant investments made on behalf of program participants. So staff study broke out a class where the revenue requirement that should be directly assigned to those participants could be segregated from the ordinary revenue requirement to be allocated among the rate schedules. Now, this is all explained in staff's direct report, but if Ameren misunderstood staff's position, it is probably worth clarifying. This misunderstanding may have prompted the voluminous testimony Ameren provided, detailing its apparent horror at staff's undertaking of a more detailed distribution cost study than has been done in the past. While in reality, staff attempted a couple of simple checks with Ameren, Missouri's work papers, was met with roadblocks and apparently unreasonable allocations. Now, all of that, again, is detailed in the testimony pre-filed by Ms. Lange. But among those more detailed areas of study, staff discovered that in the Ameren study, entire substations that are built to serve single customers are socialized to all customers. Now, there are arguments that could be made that that is reasonable. However, customers who could have requested a substation but didn't are provided substantial bill credits. Again, there are arguments could be made that that's reasonable. And it probably is, if those customers would otherwise be billed for substations they didn't require to be billed. However, between the Ameren, Missouri study and the revenue allocation shifts requested by MECG and MIEC, you have a problem. You have a situation where, on the rate design side, customers are getting credits for charges that, with the MECG and MIEC revenue allocation, those customers aren't getting billed for to begin with, out of reliance on the Ameren, Missouri study. To boil that down, customers are getting credits for charges that those customers aren't getting billed for to begin with. Now, if this all sounds complicated, it is. And I encourage you to take a close look at Lange's rebuttal testimony, where she steps through this issue. Now, turning to the industrial's rate design request, we have consensus between the industrial customers and staff that the SBS, LGS rate structures are problematic. But the solution proposed by the very specific industrial customers represented in this case is to increase the emphasis on the non-coincident peak. So let's talk briefly about non-coincident peaks. When you hear electric vehicle proponents discuss the challenges of certain rate designs, they're talking about non-coincident peak charges. The MECG proposal increases that problem, and it increases that problem without regard to the time of day that a usage spike may occur. To justify this change, MECG looks at the net cost of energy. Now, that may sound reasonable if you don't know what it means, like me. What it means is that MECG says its customers are overpaying on energy charges. But to do its math, it looks at the cost of energy as the cost of energy minus the revenues that Ameren receives from selling energy into the MISO integrated market. Not only that, but it looks at the energy revenues disbursed to the classes as a proportion of that class's energy requirement, not as a proportion of the generation that the class pays for. Again, this is a very complicated issue, and I would encourage you to ask Ms. Lange any questions you might have. Now, you will notice on the list of issues that there are multiple issues which address how certain costs or expenses should be allocated or assigned to classes. More specifically, I'm referring to 22A, B, C, and H. Of those issues, I would encourage you to focus on 22C, which is really the crux of the matter. How should the rate increase be allocated to the customer classes? And as stated in staff's position statements, staff recommends the increase be allocated to the classes as an equal percentage increase. One other issue you will hear about, that you heard Ms. Grubb speak about, concerns the names Ameren has chosen to market the time of use rates approved in its last case. In general, the current promotional names are not descriptive and in and of themselves portray the time of use rate schedules as money-saving opportunities. The names do not indicate the risk of bill increases that are attendant to the optional rates which Ameren promulgated in its last case. While names like Ultimate Savers, Smart Savers are overhyped, the names Ameren chose to market the default time of use rate schedule, Evening Morning Savers, is confusing when juxtaposed with the rebranded EV saver rate, which is now marketed as overnight savers. Finally, the quote, anytime service branding for the non-TOU residential rate schedule implies that customers who use energy anytime would not be adequately served by the default TOU rate schedule. Now, at this hearing, as I mentioned, staff will present Ms. Lange to testify and answer any questions regarding these issues. Ms. Robin Cleathurmans will also be available to answer questions as she filed testimonies sponsoring, excuse me, the staff's CCOS report. Finally, I would just like to also mention the stipulations which have been filed and encourage adoption of all of them as they reach just and reasonable resolution. And certainly, without them, I don't think we'd get done with this case in the time allotted. Thank you.
Thank you, Mr. Keevil. Any commissioner questions for Mr. Keevil for staff? Okay, I'm not hearing any. Thank you, Mr. Keevil. Opening for public counsel.
Good morning, Judge, Commissioners. My name is Mark Poston, and I'm here to represent and protect the interests of the Missouri public. That's what public counsel's enabling statute says, represent and protect the interests of the public. So who is the public? Public is defined as of or concerning the people as a whole. The positions we take in this case, and in any case, serve that purpose. They advocate for outcomes that we believe protect the people as a whole. But we all know public counsel is not the only one here serving the public. The commission and its dedicated staff of experts work to serve the public as well, to protect the interests of the people as a whole. This concept, protecting the public, is the motto of our state. On our state capitol building down the street, this idea is literally carved in stone. It sits atop the columns of the Capitol South portico, where it states in Latin, Salus Populi Suprema Lex Esto, which means the welfare of the people shall be the supreme law. This motto is also on the Missouri State Seal behind the commission's bench. And it's with this purpose that we must consider the issues before the commission in this hearing today. How do we allocate costs in a way that best protects the welfare of the people of our state? It's unfortunate we put so much time and work into settling so many big issues in this case, yet here we are going to hearing anyway. I thought once we settled revenues, divvying up the pie would be easy. We'd all agree to an equal sharing of Ameren's massive piece of investments for all classes. But some parties had different ideas. MECG and MIEC don't want the larger commercial and industrial customers to pay an equal share of Ameren's investments. You may ask what corporate customers are asking the commission to require the residential class to shoulder even more piece investment costs. Walmart is the only one willing to be identified, and I truly appreciate their openness. The rest, assuming there are others, prefer to stay hidden. Ameren has 65 large power service customers, over 600 small power service customers, and over 10,000 large general service customers. I don't believe they would all agree with what's being attempted here today, and we can't assume that the positions MECG and MIEC are putting forth are the positions of all large commercial and industrial power users. I anticipate the industrial representatives may get up here and tell you that giving them a smaller allocation than the residential and small business classes is good for economic development. Not only do we have the economic development statutes and rates to address that, such arguments ignore the fact that the Missouri public is the backbone of the Missouri economy. The rate increases contemplated here today are not going to make or break any industrial customer, but they very well could impact many residential customers' ability to participate in Missouri's economy, and it could drive small businesses to close their doors. You had two cost studies before you. The industrials claim to have performed cost studies, but that's not accurate. They only predictably latched onto Ameren's study, made modifications, and called it a cost study. You want to see what a cost study really looks like? Read carefully through the staff's class cost of service study. Their study is by far the most thorough and granular analysis of cost causation by class. There's no comparison. And the staff didn't just rely on one methodology. They tested their class cost calculations under multiple methodologies and compared the results. They did this because staff sought the best answer, not the answer that would best allocate costs away from the large power customers. The staff members that did the study are intelligent, skilled at calculating class costs, have done this many times, and dedicated to getting it right, dedicated to making fact-based decisions and in an impartial way. And having started my career with the commission and its staff, I know this study underwent considerable internal review. Staff's cost study shows us that industrial customers are not contributing enough to cover their cost of service. If only one analysis, in only one analysis did they cover their costs. If any cost shifts are justified in this case, it's to shift more costs onto the industrial customers, not less. And you have the discretion to do so, and help ease the rate shock that thousands of residential customers are most certainly going to experience with a large 8.8% rate increase if the stipulation is being filed approved. You can do this by lowering their increase to 5% in number supported by the staff's cost study. I ask that you please read carefully through the testimony of Public Counsel's Chief Economist, Dr. Jeff Mark, and Jackie Hutchinson, Executive Director of Consumers Council. They address many of the concerns impacting the residential class in these trying times. Our testimony position was an equal percent, so you may wonder why we're asking for a cost shift away from small classes. The reason we're presenting this option to the commission is because we truly think it would help many people to give them such a break and help them address problems that are specific to the residential class alone: health, safety, quality of life. Also weighing heavily in our decision is that the staff's impartial cost study suggests the large power class is not carrying their weight as is. Since we're having this hearing anyway, we may as well make a pitch for a more equitable outcome for the small customers than an equal percent share. So I hope you seriously consider a revenue-neutral shift that recognizes the smaller classes need our help more than any other class. Rate stop for the residential class occurs when rates suddenly change, and it forces low-income and fixed-income households to make concessions in how they live their daily lives. Ms. Hutchinson explains in her testimony how those living at 50% of the poverty rate may pay 56% of their income towards their electric bill. I cannot imagine that. I have no doubt that an 8.8% rate increase will force thousands further into poverty. The customer assistance programs we agreed to in the revenue stipulation will help some, but it's not going to be enough to help everyone that needs help. So any movement below the 8.8% will help keep more low-income and fixed-income households safe, especially family and elderly households, safe from not losing their heat or cooling source, safe from not having to choose between paying their utility bill or putting food on the table or buying much-needed medicine. These aren't just theoretical concerns. Many residential customers have reached out to you through their public comments and are pleading with you for help. Now is not the time to say. I ask that you please read each and every public comment. That's why the commission solicits comments, so it can consider concerns raised specifically by the public. Many of those comments talk about the pandemic. There should be no question that we're in the middle of a public health crisis. Thousands have died, hundreds of thousands may have lifelong health issues due to COVID. The public needs our help, and that's why the commission exists, to help the public in times like this. When the Missouri legislature passed the piece of legislation with the understanding that utility bills would increase significantly for Missourians, I question whether they would have put that additional burden on the public had they known we'd soon be facing a global pandemic impacting almost every aspect of our lives. We're living through an unprecedented health and safety crisis, and it doesn't appear to be going away anytime soon. I also question whether the legislature would have given favorable treatment in the PISA legislation to the very industrial customer Tier 1 Team 1. The same classes wanting to contribute less to the PISA investment already have a lopsided protection in the statute that caps their impacts and requires their share of PISA costs above the cap to be passed along to other customer classes. I'm referring to section 393.165.6. It requires all other classes to pay the industrial share of PISA investments once the cap is hit. It's my understanding Ameren has not hit that cap yet. But when it does, and we know it will because they're moving full steam ahead with their investment plans, industrial costs will be forced upon residential and other small classes. It's just a matter of time. For all these reasons, we ask that you help the smaller classes recognize the inequity in how the industrials are not covering their costs and allocate less costs to the residential and small business class. Or at minimum, order an equal allocation to all classes. Either outcome can be supported as just and reasonable under the facts of this case. Anything else is simply not supported by the record or any notion of protecting the public interest. And I'd like to briefly hit on the rate name change issue. It seems clear from both sides of this issue that we want to avoid customer confusion. Ameren raised good points in their opening, that they've already been marketing these plans. They've signed up, I believe, 100, 200,000 customers. I can't believe it, or can't remember the number. But this fact should be balanced against the fact that the vast majority of residential customers have not migrated to one of these rates. So the ship hasn't sailed for the majority of the customers. And any name change could be easily communicated to customers. So staff raises a legitimate concern. The names could confuse and mislead. The Commission agrees the time to make these changes is now. Thank you.
Thank you. Any questions for public counsel?
Judge, this is Commissioner Roop. I got a question if no other commissioners have one yet.
Go ahead.
Great. So is it public counsel's opinion that the customer can opt out of the TOU rate plans if they decide that the current plan is not the correct rate plan for them? Is that still the way it is?
I would defer you to our witness. Dr. Jeff Mark will be up here today. He could probably help you answer that question. I can't answer that for you.
All right, I'll ask Dr. Mark. Thank you.
Thank you.
Any other commissioner questions? Thank you. Opening for MIEC. Yes.
Good morning. May it please the Commission. My name is Diana Pasha, and I represent the Missouri Industrial Energy Consumers in this case. The main concern that the MIC has and has had in rate setting is primarily making sure that rates are fair and equitable and reflect cost of service. This is a consistent principle of the MIEC, but it's also been a touchdown of rate making in Missouri and for the Commission for decades. And it's appropriate to the extent possible to move to cost of service in a way that doesn't cause rate shock, but doesn't also cause inequities that are perpetuated from rate case to rate case and could get magnified and increased over time. Some of the reasons that the Commission has in the past and the courts in many states have adopted cost of service as a starting point is that it establishes a fair rate that sets the right incentive. And that includes not only equity, it includes conservation, incentives for conservation, incentives for demand side management, and it minimizes costs by making sure that customers who would reduce load or leave the system are charged appropriately, so it's more likely that they will stay and help reduce the cost for all. So there are many reasons to set rates based on cost of service. Ameren has filed a class cost of service study that we think appropriately allocates the cost of service. Their methodology is the average and excess method, which is a very accepted conventional method for allocating rates, and is one of just two methods that Ameren really could have appropriately chosen, in our opinion, due to the fact that it's a summer peaking utility. So it's a very appropriate and traditional method, and Ameren does propose an equal percentage increase, but it doesn't have any objection to the recommendations of the MIC and the MECG regarding some class cost movement toward class cost of service. The MIC's class cost of service study is sponsored by Mr. Morris Brubaker, who performed the study using the A&E methodology, which is the same methodology that Ameren used, but with some modifications that were specific to his study to make it better reflect cost of service. Even with those modifications, the differences are not dramatic. The results of the study are shown in Mr. Brubaker's exhibit COS4 to his direct testimony. Mr. Brubaker's study shows that the residential class is producing a below system average return. All other major classes, except for the small general service class, which is at cost, are producing returns that are far in excess of the system average. Mr. Brubaker's direct testimony schedule COS6 shows the adjustments that could be reduced, could be made or needed prior to any overall rate change in order to move residential customers and other customers to cost of service. However, his recommendation is not for a full movement to cost of service. His recommendation is for only a 50% move toward cost of service. And the way that could be accomplished would be for the revenue increase to be applied as an equal percentage to the base rate revenues of all classes after making interclass adjustments. This would result in a revenue requirement increase to the residential class of 7.8%. All major classes would receive a rate decrease toward cost of service. Again, direct testimony schedule MEP COS6 is the schedule that shows what the magnitude of these rate changes would be. The Commission staff's recommendation is manifested in a report that uses a range of methodologies for various Ameren generating facilities in 10 categories, and then considers a range of allocation methodologies. For some generation categories, the staff relied only on the energy allocator under the invalid premise that these generation facilities exist simply to provide renewable energy certificates or the generation of renewable energy certificates that are for resources that are non-dispatchable. There is no valid basis for staff allocation. All of the resources in these categories have capacity values and generate energy. The fact that the output receives RECs is incidental to the generation. And this is just one example of the flaws in staff study that make us very concerned that if the staff's recommendations were to be adopted, that rates would depart so greatly from cost of service that it would be extremely disruptive not only to customers but to Missouri's economy. The staff relies very heavily on a document that is not really an authoritative document at all. It's the regulatory, it's the RAP manual that it was published in 2018, and it tries to develop new forms of cost allocation and rate design that it feels would apply to new generations of technology. The essential feature of the RAP manual is to increase the cost of generation resources on the basis of class KWH rather than on cost causation. The proper resource to use if you want a manual to help set rates in an appropriate cost of service-based way is the neighborhood cost allocation manual, which is really the authoritative source that has stood the test of time and has been relied on by commissions. It is an authoritative source versus the regulatory assistant project manual, which simply is an advocacy piece for an interest group, and it is not necessarily objective. It reflects the view of its authors, and it's not relied on it shouldn't be relied on for evidence. The staff has some significant criticisms in Ameren's record keeping and assignment of distribution functions. They seem to think that Ameren's inability to identify certain costs for certain specific distribution lines and other delivery equipment makes Ameren's studies imprecise and unreliable. Much of the data sought by staff would not necessarily add any useful or meaningful information to improve the accuracy of cost allocation studies. Rates are designed to serve customer classes, and unless the rates were set separately for each individual customer, the added information is not of value. As concluded by Mr. Brubaker based on his 50 years of experience, Ameren's study is consistent with the level of detail and practice of other electric utilities. The Commission staff has also recommended that Rider B be suspended until Ameren, Missouri provides information necessary to include the cost of primary customer substations in the bills of primary customers. This recommendation is illogical, as noted in Mr. Brubaker's rebuttal testimony. He said it does not make sense and is illogical. The substations that allow primary customers to receive the credit are owned by the customer, not Ameren, Missouri. The Rider B credits are necessary to recognize that they are not using Ameren substation assets. This recommendation shows a fundamental misunderstanding by staff and should be rejected. These examples of flaws in the staff study are reasons that the Commission should not adopt the staff's recommendations. The staff has before it cost studies of the MIC and Ameren that follow conventional methods and are supported also by the MECG. There is a concern by residential customers, customers in the SGS class, low-income customers, about cost shifting. Cost shifting is a misnomer, and it's not something that the MIC is seeking. The MIC and other customers who want cost of service-based rates are actually just seeking a proper allocation of costs that exist. Ameren's costs are its costs. There is no effort to shift costs. There is an effort to develop a rate design that is fair and equitable and promotes the policies of conservation, gradualism, economic development, and avoidance of rate shocks. Those are all appropriate considerations, but the first consideration, the starting point, should be cost of service. Shifting cost to other customers is not anything that the MIEC wants to do, and it's not a proposal that is on the table from any party. The only proposal on the table is to develop an appropriate cost allocation, identify the costs, allocate them, and develop a percentage increase for each class that meets all the concerns and considerations that the Commission should be taking into account. The danger of not addressing subsidies in this case is that they will continue to grow. Ameren has new incentives under Missouri law to increase rates more quickly and to spend more on investments. If the subsidies aren't addressed now, it will become increasingly difficult to modify them later. And as they've been enshrined for many years, these are very long-standing subsidies. It's important to make some progress toward cost of service in every case so that we don't end up with a situation where customers have subsidies that are large enough that there could be disruption to Missouri's economy. For all these reasons, the Commission should adopt Mr. Brubaker's recommendation to make a 50% movement toward cost of service in this case. Thank you.
Thank you. Any questions from the commissioners for MIEC?
Hey, Judge, it's Commissioner Roop. I have one if none of the other commissioners do at this time.
Go right ahead.
Thank you very much for your commentary. Wanted to clarify, when you were talking about the RAP speakers, the commission's had them at various different commission workshops. So is it MIEC's position saying that RAP is an unreliable source of utility policy information?
Not at all. Our position is that it's not an authoritative source for purposes of establishing rate allocation, cost allocation methods and cost of service studies. It is like many other groups that represent and you know, are advocates for stakeholders. You have EEI for the utilities. You have Alcon for industrial customers. You know, the Regulatory Assistance Project can provide valuable information, but the Rate Assistance Project manual that is being relied on very heavily by the staff in this case, it is not anything more really than some speculations about how rate making might change due to new technologies in the future. It creates some ideas, but the report admits that there isn't really sufficient information to make the kind of changes that it's recommending. But moreover, and more importantly, those changes would take rate making way out of the realm of cost of service. And cost of service principles, conservative traditional principles, accommodate new investment and new technology very well right now. So there is no need to dabble into rate making areas that are non-cost based. In fact, there are dangers to that, and so it's important, we think, to point that out, not necessarily to say that the Regulatory Assistance Project is unreliable, but simply that it shouldn't be relied upon as an authoritative source for the Commission and for evidence in this case.
Okay, thank you for clarifying.
Anything else from the commissioners? Right, thank you. Then opening for Legal Services of Eastern Missouri.
Thank you, Judge. May it please the Commission, my name is Paul Bars, and I am appearing on behalf of Legal Services of Eastern Missouri. Legal Services is a private nonprofit organization dedicated to advancing justice through legal representation, education, and supportive services in 21 counties in Eastern Missouri. As part of its mission, Legal Services assists low-income families and individuals facing housing issues, including eviction, utility debt and disconnections and reconnections, poor living conditions, loss of housing assistance, and discrimination. Utility assistance is core to this mission because Legal Services clients' health, safety, economic and personal well-being, and sometimes their very survival depend upon their ability to be safely housed and have uninterrupted access to basic utility services, including electric utility service provided by Ameren. Perhaps needless to say, the plight of many of Legal Services clients is especially difficult given the COVID pandemic that continues to play havoc with people's lives and health, jobs, housing, and finances, and has had a disproportionately severe effect on low-income individuals and families. With this background, Legal Services intervened in this rate case to try to assist its clients by keeping electric service affordable and by improving Ameren's existing programs that are designed to support low-income individuals. I'm very pleased to say that on the latter front, Ameren has stepped up to the plate. The first stipulation agreed among the parties, and which Legal Services hopes the Commission will approve, includes significant improvements to Ameren's existing low-income programs. On the first point, the affordability of electricity service, however, Legal Services is highly concerned that the revenue requirement increase agreed among the parties in the first stipulation will lead to rate shock for residential customers, including Legal Services clients, if interveners MIAC and MECG have their way with respect to issue 22C. That is the allocation of costs. Such an increase imposed on residential customers would lead to even less affordable electricity bills for hundreds of thousands of Ameren Missouri's residential customers who already have difficulty paying their electric bills in a timely manner, and would predictably lead to tens of thousands more residential customer disconnections. Where do those numbers come from? In staff's most recent report on utility data requests published just 2 weeks ago on November 22nd, Ameren reported almost 12,000 disconnections for non-payment in each of September and October, a roughly 25% aggregate increase over pre-pandemic levels for the same months, and approximately 216,000 and 199,000 customers with past due accounts in September and October respectively, a staggering 44% aggregate increase over pre-pandemic levels for the same months. These numbers are really all the evidence needed here to demonstrate the inequity of imposing an unnecessarily high rate increase on Ameren Missouri's residential customers. Hundreds of thousands of those customers, including legal services clients, are already hurting and simply cannot and should not shoulder more of the rate increase than is absolutely necessary. Legal Services therefore supports public counsel and consumer counsel positions that the Commission should use its permitted discretion to minimize the rate shock to residential customers and limit the increase to their electricity bills to no more than 5%. Legal Services believes that Commission support for this approach will improve the lives and protect the safety of hundreds of thousands of Missourians, including Legal Services clients, by helping keep their electric service connected and relatively affordable. And Legal Services believes that over the longer term, this approach will also accrue to the benefit of Ameren and all its customers, both large and small. It should be obvious that keeping customers connected and maximizing the likelihood that bills are paid are each critical to Ameren's very existence and hence the reliability of all of its customers' electricity service. All Missourians deserve and are entitled to receive safe and reliable utility services at just, reasonable, and affordable rates. Thank you.
Thank you. Any commissioner questions for Legal Services? Hearing none, then we'll move on to Consumers Counsel.
Good morning. May it please the Commission. I'm John Kaufman on behalf of the Consumers Counsel of Missouri. We're very happy to be here today, and let me start with asking you to approve the first large stipulation agreement that's been filed in this case. We were happy that the bulk of the issues in this case have been resolved amicably, and we would like to express sincere gratitude to Ameren Missouri for its agreement to step up the programs that it has for providing additional low-income support through its Keeping Current program, which has really, I think, led the state in showing how a collaborative program of that type can work, and to agreeing to provide half of the money from its own shareholder contributed fund. We also are excited about the critical needs programs and the provisions relating to homelessness that have been included in that stipulation. And so that is, I think, quite good and in the public interest. We did not file a written position statement on issue 17, which relates to the names, but I wanted to join in the staff and public counsel's concerns about the name, the ultimate saver names, and the concern that we have about customer confusion is about the use of these marketing names. I can tell you from a recent experience that I had involved in an Arizona case, the largest utility in Arizona, Arizona Public Service, had a couple of programs that it used for demand programs and time of use programs, and they had named those programs Super Saver Plus and Super Saver Max. And it wasn't clear exactly what they were, except that they were Super and they were Plus and they were Max. And they were developed based on extensive marketing research and focus grouping and so forth, and they did attract a lot of customers. They were attractive names, but they created problems for many customers who didn't receive savings. Depending on your usage and how you use your energy, there's no guarantee that these programs are going to save. And so I will cite to this to the case and to the investigation that was done of the rate comparison tool in Arizona. I think it would be a cautionary tale that when the regulatory body approves these various different rate plans, that can be very confusing, that they be as informative as possible about what they are, and that they not go too far down the path of marketing and promoting plans, rather supply the most accurate information for consumers to make informed decisions. So I think there is reason to be concerned, and we share those concerns of staff and public counsel. On the class cost of service study, the CCOS, I think it's important for the Commission to realize that there is no golden perfect answer. The large customers will be telling you today that A&E, average and excess, is by far the best, but it's one of many tools that provide information. And I think that the CCOSS studies are very important. They provide a lot of information. And again, the staff did the most detailed approach. The staff did analysis that shows the various discretionary points in the study. If you look at the staff, they did a broad kind of differential approach, which shows if you make an adjustment here, you make adjustments there, there is a range of reasonableness. There are many class cost of service studies. In fact, there's half a dozen different potential ways to analyze these costs in the 1992 neighborhood study, which is sometimes called the Bible. 30 years old, and I think it should be supplemented by as many other sources as possible with staff. I think the RAP study is, while they are advocates for various environmental and consumer issues, they are very authoritative. I think it's right to consider that in evidence. But after you've looked at the vast spectrum of class cost studies, you'll see some of them will benefit large industrial customers over residential customers. Some will favor residential customers over industrial customers. It's good to look at the panoply of issues to see whether things are too far out of whack. But at the end of the day, this cost study, this class cost study, or class cost studies that you look at is just one factor amongst many of either 10 or 16, depending on how you look at it, doctrines that govern rate design. The Public Service Commission has to take this cost information and weigh it against all these other various, sometimes conflicting, public policy concerns. And I would suggest that some of the most important public concerns that have been listed here today and been recognized by the Commission and the Court is the avoidance of rate shock, gradualism, and public acceptance. The Commission has to be aware of what the impact will be on the broader rate-paying public. And I hope to cite to some early cases from the 1970s and the 1980s, where the Public Service Commission was operating in a time of frequent rate cases and inflationary pressures. And at that time, there was much discussion and debate over what is rate shock. And there's never been any definitive answer. But at that time, there was much debate about whether 10% increase in a bill was rate shock by definition. And I think that the Commission ultimately said it wasn't, but it was a rule of thumb that was discussed frequently back in the previous period of time when inflation was a serious threat. And in this case, we are getting close to that. If an equal percentage of application of cost is spread amongst the various revenue classes, it would be an 8.8% increase. And then that would vary customer based on usage. For instance, in the residential class, we've agreed to keep the fixed customer charge where it's at $9, and so the increase would be applied almost completely on usage. And so there will be customers who use above the average that on an equal percentage basis would be over 10%. And I think that it's fair to say that that is a psychological threshold. It's been my experience that you have considerably more public outcry if a utility is requesting over 10% than if it's requesting 9% or less. And so I think that should be considered a ceiling that the Commission considers very carefully. And we have large customer classes here today advocating for on top of that 8.8%, that the residentials also face a 7.8% shift on top of that. That would be over 15%. And I think that would be outrageous. We support the Public Council and other parties that have said that if you are going to make any other change other than equal percentage, that you favor the broad general body of residential household customers, and that you limit their increase to 5%, and or that you find a number between the average and the 5%, and that in this time of inflationary pressures, that you keep your eye on that primarily. We believe that it's the residential class that will that having to absorb the rate increase in this case would have the greatest impact on the general economy in Missouri. There are already thousands of customers that cannot pay their current bills and are being disconnected. And we have a variety of tools, and we will have more tools to help those who are medically vulnerable and who have other problems. But even now, barely over a third of customers who are eligible for energy assistance programs, even with the considerable money that's been made available federally right now, is not made available. So that means that there are people who are technically low income and who are not benefiting from these programs. The main impact to these customers will be from whatever decision is made in this case about the overall increase. And I think it's also important to realize that these large industrial customers who are here today asking for, asking for less of a rent increase, they already have successfully lobbied for protections in the law for their electric rates. Residential customers have only the Public Service Commission to protect it from rates that could be considered rate shock or out of whack. And so I urge you to be fair to the smallest customers in this case. That's all that I have.
Thank you.
Any questions?
Any commissioner questions for Consumers Council? Okay, I'm not hearing you. Thank you. And we'll move to opening for MECG.
Good morning, David Woodsmall on behalf of the Midwest Energy Consumers Group. Now, I'll admit here that I'm here today solely to represent industrial customers. My attendance here today is mandated because industrial customers otherwise go unrepresented. You've heard OPC claims that it represents the public in general, and I've stated repeatedly here and in the General Assembly that this is not true. OPC does not represent industrial customers. OPC only represents residential customers. And even then, you have to question whether they represent all residential customers. Given its position on customer charges, it's certainly valid to assume that OPC only represents those residential customers that use a less amount of electricity. OPC doesn't represent industrial customers, and this is best exemplified by the fact that OPC, at all costs, continues to ignore the residential subsidy. I've practiced in many commissions, and I have never seen this same dynamic in those other states. You hear, once again, OPC's litany of excuses for ignoring the residential subsidy: COVID, the economy, the magnitude of the increase, unreliable billing determinants, estimated customer bills. It goes on and on and on until OPC recognizes the residential subsidy. They cannot say that they represent the public. Now let's turn to the staff studies here today. Staff will tell you they represent an objective, balanced approach between the company and the customers, and then between the customer groups. Now think about this. When we do the revenue requirement side, what you typically see is the company's revenue requirement. You will see the customers, OPC, and the industrial customers at the other end of the spectrum, and staff will be somewhere in between. That certainly looks like a balanced approach. And on return on equity, you see the same dynamic. You see the company, you will see OPC and the industrials at the other end of the spectrum, and staff will be somewhere in between. But what happens on this issue, on revenue allocation and class cost of service study? You don't see that same dynamic. Instead, what you see is staff come in, and OPC, legal services, Consumers Council all fall blindly behind staff study. They don't do their own studies. They know they don't have to, because they know staff is presenting a partial approach that favors residential customers. So that's why I'm here today. Here are the issues that I'm going to talk about today. First, I'm going to talk about class cost of service issues, including the allocation of fixed production costs. Second, the allocation of non-fuel, non-labor costs. Third, the allocation of distribution costs. Then I'll move from that to address the revenue allocation. Then, once we know how the revenue should be allocated, how should you design the rates for the LGS and SP class in order to avoid intra-class subsidies and to send proper price signals? Then I will talk about a proposal MECG has made for future rate design structure. Finally, I'll talk about the Rider B credits. OPC and staff argue that the industrial class did not conduct its own class cost of service study. This is patently incorrect. Agreement between studies, as what occurs between MIEC study and Ameren, does not mean both studies weren't conducted. It means simply that there was agreement. Where there was disagreement, MIEC and the industrials have noted that disagreement, but that doesn't mean both studies weren't completed. There were studies. There is agreement in many places between MIEC, the industrials, and Ameren. Both conducted class cost of service studies. So the largest issue in any electric class cost of service study is the proper methodology for the allocation of fixed production costs. Many allocators are straightforward in a case. For instance, how do you allocate the number of meters? Every customer has a meter. You count the number of customers, they each get a meter. That's roughly it. But how do you allocate the investment in nuclear units and coal units and those type of things? You don't have a nuclear unit built just for industrial customers or another nuclear unit built just for residential customers. You have a nuclear unit. So how do you allocate the investment in those generating units? And that's what the fixed production cost allocation issue is all about. This issue has been changed recently through the enactment of Section 393.1620 just this last legislative session. That statute mandates that the Commission only consider class cost of service studies that rely either on the average and excess method or one of the other NARUC-recognized methods for the allocation of costs for nuclear and fossil units. That's important to recognize. This statute only applies to nuclear, coal, and gas units. The NARUC manual consists of the average and excess, which is spelled out explicitly in this statute, as well as 12 other different methodologies. In this case, Ameren, MIEC, and MECG all recommend that the Commission use the average and excess method expressly recognized in the statute. Ameren, MIEC, and MEC recommend that the average and excess not only be used for the fossil and nuclear units, but be used for all generating units. The method is inherently reasonable because it recognizes not only each class's contribution to peak demand, but also each class's energy needs. The average and excess recognizes the energy needs of a class in what they call the average component. That is derived by taking all the energy and dividing by the number of hours in a year, 8,760, and that comes up with the average component. The excess component is the contribution to peak demand. Now, the average and excess has been expressly adopted in Missouri. Judge, you'll recall this from the 2010 case that you sat on. There, the Commission said that the average and excess, quote, is the most reliable of the submitted studies. This methodology has not only been recognized in Missouri, but also numerous other states, and I will include a litany of those cases when we get to the briefs. But here's a quote from a Texas case. Quote, the continued use of the average and excess 4CP allocator is the most reasonable methodology for allocating production and transmission plant amongst classes. The staff's approach here today is radically different. Staff starts off by presenting 3 different studies for the allocation of the nuclear and fossil units. They first start out by showing an allocation of those investment under either the coincident peak the peak and average approach, or the average and excess approach. Staff then allocates all other investment, so all the investment in hydro and renewables and wind and solar on the basis of class energy. Let's start out with the first step, where staff uses either the coincident peak, the peak and average, or the average and excess. As Mr. Brubaker points out, using the average and excess or the coincident peak are appropriate methodologies. Where staff goes wrong is when they present another study based upon peak and average. That should be summarily rejected. In the same case that I mentioned from 2010, the commission points out the shortfall with the peak and average approach and says that peak and average method double counts the average system usage, and for that reason is unreliable. So let's just get rid of that. And I hope this will show how it double counts. What you see here is a diagram, and you see this is just a simplified diagram of a class load requirement, load profile. And you see here a class maximum demand of 100. Now, under the average and excess maximum demand of 100 and an average demand of 60. Under the average and excess approach, you have the average component, 60, which is multiplied by the system load factor. Then you have the excess, the 40, which is multiplied by 1 minus the system load factor. So it distinguishes between the two and keeps them separated. On the peak and average, and the reason the commission said it double counts is because it uses the same average component, the 60, multiplied by the system load factor, but then it does the whole peak and multiplies that by the 1 minus the system load factor. So what you see is the average demand counted twice. And that's good for residential customers, but it's also the reason that the commission said it double counts and is unreliable. So let's move on to the second part. I said staff allocates using the fossil investment using either A&E, CP, or peak and average. But then it allocates all other investment on the basis of energy usage. This approach is inherently faulty, because it implicitly finds that these renewable units don't provide any capacity value. We all know that this is incorrect. Ameren relies on each of its generating units to meet its system peak. The fact is not only acknowledged by Ameren, it is also acknowledged by the commission in its IRP rules, where the commission's IRP rule says that, I think it's the fourth volume of the IRP, where the utility is supposed to recognize the capacity of all generating units. It's also recognized by MISO when it calculates a utility's resource adequacy. It includes all units as a contribution to the capacity needs. So ignoring the capacity value of these renewable units and implying that they only provide an energy component is absolutely incorrect. Finally, it is important to recognize that the statute or this methodology of using the energy allocator is not a NAGRUC recognized methodology. Now, I'm not saying it violates the statute, because the statute only applies to fossil and nuclear. But it is interesting that, once again, staff has gone outside of a NAGRUC recognized methodology. So, after we ignore staff's methodology, let's look at the two A&E approaches that are remaining, or the three. You have an Ameren approach, an MIEC approach, and an MECG method, or A&E. You can see the results are amazingly coincident, or similar. The residential class under Ameren's approach would be allocated 52.53% of the production cost, the fixed production cost for Ameren. Under MIEC's 52.5%, under MECG's 52.79%. So all three lead to amazingly coincident results. Let's move on to the next class cost of service issue. This issue involves the allocation of non-fuel, non-labor costs. We're talking about $69 million of cost here. Ameren proposes to allocate these costs on the basis of class energy. That implies that the costs are timed, that these maintenance costs are timed because of the generation of energy. But that's not true. This maintenance on these plants are all incurred simply on the passage of time. They're scheduled months, years in advance. So whether there's any energy generated, these maintenance costs are incurred. So it's silly then to allocate these costs on the basis of class energy when energy has nothing to do with the incurrence of these costs. For this reason, Mr. Brubaker says that these maintenance costs should be allocated in the same manner as the underlying plant. As he calls it here, costs follow plant, but expenses follow plant. So these should be allocated similar to the underlying plant, that is on the basis of average and excess approach. The final class cost of service issue is the allocation of distribution costs. In Ameren and MIEC's class cost of service studies, both attempt to classify distribution costs as first either customer cost or demand-related costs. The primary tool for distinguishing between these two is either the zero intercept or the minimum size approach. So you apply this test, the amount that hits at the zero intercept is classified as customer related. Anything above and beyond that is then demand related. The customer related costs are simply allocated to the classes based upon the number of customers. The demand related is allocated amongst the classes on the basis of their contribution to the coincident peak. The important part of all this is that they are allocated. Staff's approach here is radically different. Staff criticizes Ameren because of lack of data, because staff wants to be able to assign, not allocate distribution costs. Staff demands that Ameren provide it with the cost, age, and other statistics related to each piece of the distribution network. Staff then hopes to assign each component to specific customers and classes. As Ameren characterizes this, it is reflective of staff's, quote, hyper-focus of assignment of costs in an environment where allocation is the accepted norm. As Mr. Brubaker points out, staff's suggested assignment of distribution costs fails to recognize the rate-making concept. Rates are set for a class. Rates are not set for individual customers. Therefore, you don't go through and try to determine how much of each distribution component is used to serve ABC factory. All the customers in that class are provided an average rate. And so trying to break down specific components and determine how much of each component goes to serve each individual customer is completely contrary to the rate-making methodology. Okay, we've gone through the outstanding issues with the class cost of service study. Let's discuss now how the class cost of service study affects the revenue allocation in this case. This is the point of doing the class cost of service study. As I mentioned earlier, the staff studies are faulty due to the reliance on the unreliable peak and average fixed production allocator, the over-reliance on the energy allocator, and their misplaced attempts to assign distribution costs. So let's look at the studies that are remaining. You have the MIEC study and you have the Ameren study. And again, there are noticeable consistencies. First, both find the existence of a residential subsidy at the detriment of commercial and industrial customers. Specifically, both of these studies find that even without any rate increase in this case, the residential class should receive an increase of 7.3 to 7.8%. Again, that's before any increase for Ameren. Any increase in this case should be over and above that. In his testimony, Mr. Chris points out that this subsidy has been long-standing. Looking at just the LGS SP rate class, this class has been paying rates above cost of service for decades. In the middle column, you can see what Ameren was earning at the time of each case. So, for instance, in the 2008 case, it was earning 4.06%. But at that time, you can see in the first column what the LSP rate of return was. At that same point in time, Ameren was earning 7.01% from this class. So if they're earning more from one class, it's obvious that they're earning less from another class, and that's the residential class. This is the definition of a residential subsidy. If you didn't have a subsidy, you would see all those numbers matching up. So we are not proposing, as Mr. Kaufman may have insinuated, that you move this entire 7.8% and then tack 8.8% on top of that. We're not proposing that. We are recognizing some element of gradualism. In MECG's approach to this case, Mr. Chris states or recommends that the Commission consider the difference between the amount requested in this case and the amount actually authorized. In this case, Ameren sought an initial rate increase of $300 million. Under the stipulation, the increase is $220 million. So there's an $80 million difference. MECG recommends that the Commission take half of that, $40 million, and use it to address the residential subsidy. The other half would be shared amongst all classes. So in his testimony, Mr. Chris presented a numerical example. And with a great deal of foresight, Mr. Chris used a $221 million overall revenue requirement. The overall revenue requirement was 220, so the numbers are amazingly applicable here. Under that example provided in his testimony, applying half of the difference to the residential subsidy, the residential class would see a 10.4% rate increase. Now note that initially, Ameren was wanting to give the residential class about an 11.95% rate increase. So you shouldn't be concerned about rate shock because Ameren told you 11.95% was reasonable for the residential class. So we are proposing a 10.4% increase. If granted, that would mean that the large general service, small primary, and large primary classes would see a 6.7% increase. The practical effect of all this, the bottom line, is by adopting MECG's revenue allocation approach, the Commission can eliminate 41% of the residential subsidy. I want you to think about the critical nature of this residential issue. As previously mentioned, the residential subsidy has been long-standing. It has been around for decades. The existence of a residential subsidy through all Missouri electric utilities have left the General Assembly and the utilities scratching to try to come up with temporary fixes. How do we fix the residential subsidy if it can't get fixed here? For instance, the General Assembly passed a statute providing for a special rate for aluminum smelters and steel mills. Next, the General Assembly passed a statute providing for special discounts for large customers that either locate or expand in Missouri. Finally, as you know, Evergy has filed a docket to provide a special rate for data centers. I would tell you, each of these Band-Aids, if you will, may have not been necessary if the residential subsidy was addressed. If the residential subsidy was addressed, if industrial rates were at cost instead of paying this residential subsidy, you wouldn't need all these fixes. This is your chance to fix the problem. So we finished the class cost of service study issues. We've addressed the appropriate allocation of revenues in this case. How do we design the rates of the large general service and small primary rate class? It is a well-established axiom that rates should be collected in a manner that reflects how the costs are incurred. Therefore, fixed costs, those costs that do not vary with the amount of electricity generated, should be collected through a per kW demand charge. Meanwhile, energy charges, those truly variable costs, should be collected through energy charges. This is not what is happening in the LGSP class. What you see here is a class cost of service study. And you see that for this class, 76.7% of costs for this class are demand related. They are not variable. That said, only 14% of the revenues for this class are collected through demand charges. And for the SP class, only 9.6% are collected. Turning to the energy. In actuality, energy costs are about 21% of total cost. But Ameren collects almost 84% of its revenues from the LGS class through energy charges. You see a complete mismatch. So what needs to happen is we need to collect more costs through the demand charge and less through the energy charge. The implications of this are, if you continue down this road, is to further exacerbate the intra-class subsidies. You are collecting more from the high load factor customers in this class and less from the low load factor customers. The other implication, it sends wrong price signals. As you can see here, it is indicating an energy charge should only be 20% of your bill, but in actuality, it's 84%. So it's sending the price signal that energy is the expensive component. So customers aren't really looking at their contribution to demand. If you set these things properly, customers would be saying, wow, look at the demand cost. I need to make sure that I move my usage and level out my usage such that I don't incur these demand costs. We need to send proper price signals. So what is MECG's proposal? MECG recommends that the commission increase the demand charge by 3 times the percent increase for the class. So for the LGSSP class, I mentioned earlier that we recommend an overall 6.7% rate increase for the class. Therefore, under this proposal, demand charges should be increased by 6.7 times 3, 20%. The remainder of the increase for this class would be spread evenly throughout all the energy charges. So 2 more issues real quick. If you've ever sat down, the LGSSP rate design is based upon a concept known as hours use structure. I dare you to sit down with the tariff for this and try to understand this. I would say there's less than 20 people in the entire state that can understand this hours use structure. It's impossible for customers to understand. So price signals that are implicit in that structure are lost. Customers can't understand it. Customers can't calculate their bills. They are blindly paying these bills because they can't sit down and price things out. Therefore, they're unable to take steps to try to minimize electric bills. The hours use rate structure is archaic. MECG's proposal, rather than use this hours use structure, and given the coming AMI functions, we recommend that Ameren be required to present an alternative in 2025 or when AMI is fully deployed. And that alternative would be more clear demand charges and energy charges, not this hours use structure. I believe in its position statement, staff agreed with this. So it's a proposal that we'd like to see looked at for a future case. Finally, Rider B issue. Rider B is a credit that's given to customers served on the primary rate schedules for providing their own substations. Small primary and large primary are just that, customers served at primary voltage. So in order to get the voltage down to primary levels for these customers, Ameren has to provide substations for them. But Ameren doesn't provide those substations for all customers. Some customers have incurred the cost of constructing and maintaining and operating these substations on their own. So they shouldn't pay the same amount as the other customers that rely on Ameren. So in order to fix this, we back out, if you will, the cost of that substation for these customers that provide their own substation. This is the Rider B credit. Staff wants to suspend the Rider B credit. I think, Mr. Wills in his testimony went through and said this is punitive. He notes that this alone would lead to an increase of 4 to 5% for many of these customers. We could talk about that more, but, this credit has been around quite a while, and it makes no sense to try to eliminate it at this point. And that was all I had.
Okay. Any questions for MECG from the commissioners?
Thank you.
All right, thank you. That would be the last opening statement then. We'll take a break in a little bit here, but I want to address one more thing first. There's a couple pending motions. Mr. Keevil mentioned staff's motion in his opening. Staff was filed a motion to amend its list of issues and late file a position statement. And then Ameren responded with its own motion to late file a position statement on the newly added issue that was added by staff. Does any party have any objection to those motions? I'm seeing a lot of shaking heads out there, so I'll assume there are no objections, and both motions will be granted. And with that, let's go ahead and take a break. We'll come back at 10:30.
Keep track of it.
and admittedly, a lot of the recommendations I think Ameren is following. So I wouldn't put them in the same category as APS, but we're still in the early days of this.
So without having them, without monitoring it and having a quick report, when would we, the commission, see results of how, if there is confusion, if we don't do anything? When would be the first we would kind of, or they would be mandated to give us information?
Well, I mean, if you request it, or if you make that a requirement, I mean, they'll have to follow it and follow up with whatever, you know, you're requesting. In terms of when you might first, sort of a canary in the coal mine.
Yeah, assuming we don't request it and we don't say you need to let us know, when would be the first? Would it be the next rate case, or?
It would be the next rate case, or it could be a filed complaint case. You know, that could arise. I think, you know, APS is in sample size of 1, but if that's any indication of what, you know, worst case scenario would be, you would start to hear it in the press. And that could push a complaint case.
All right, let's see here. I think that's all I had on that issue. Let me look at the next one. Pause just a moment, sir.
Sure.
No, I think that's all I had for Dr. Mark today. Thank you very much.
Thank you.
Thank you. Then move on. Any other questions from any other commissioners? All right, then move to recross. Let me just ask anyone wish to recross.
Yes, Your Honor, just briefly, I wanted to clarify in your discussion with Commissioner Ruth, you described the website that's available on Time of Use Rate. Are there also mailers that go to customers that provide some details as well?
Yes, there are.
And with regard to APS, which you mentioned, was one of the notable differences between Ameren, Missouri TOU residential rollout and APS is that APS's old flat rates were not still available. And instead, they were being shifted to what was deemed to be the best rate for them. Is that right?
I think that's accurate.
And there was also a unfortunate error in the calculation of how the best rate was selected, right?
That is absolutely true. I think that's a real compelling point where APS got penalized.
And then under the APS rollout, there wasn't flexibility to opt into different rates, the same flexibility that Ameren Missouri's rollout is allowing, right?
I don't know that off the top of my head.
Right. Thank you very much for your time. Thank you.
Thank you. Any redirect?
Yes, thank you.
I'm sorry. Go ahead.
I have just one question. Dr. Mark, are you aware of how Ameren Missouri on their website estimates the demand determinant for the example bills under the ultimate savers rate?
I do not.
Okay, redirect.
Thank you. Ameren asked you questions about our class cost of service proposal. And did OPC do a cost study?
No.
Is our position on class costs supported by the staff's
Yes.
class cost of service study?
Yes, it is.
Thank you, that's all.
All right, thank you. And Dr. Mark, you can step down.
Thank you.
Before we move on to the next witness, for Ameren, you offered, or you marked number 74, which that exhibit. Do you wish to offer that?
It is an excerpt of
So it's already in?
Harding's direct testimony, which is, yes, which I believe is exhibit number 44, and he's going to be presented later, so I guess we don't have to
Okay.
move it in.
Okay,
Thank you.
we'll move on then. The next witness then is Robin Cleaver for staff. If you'd please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth. Thank you. And you can inquire.
Thank you, Your Honor. Good morning, Ms. Kleethermes. Can you state and spell your name for the record, please?
My name is Robin Kleethermes, Kleethermes.
Thank you, Ms. Kleethermes. How are you employed?
I'm employed by the Missouri Public Service Commission as a regulatory compliance manager of the Tariff and Rate Design Department.
And have you prepared for filing in this proceeding direct, rebuttal, and surrebuttal testimony, as well as staff's class cost of service report, pre-marked as exhibits 204, 205, 214, and 230?
I have testimony sponsoring the cost of service report. Okay, if that's what you're meaning rather than testimony in. Okay, with that clarification, yes.
Thank you. And do you have any corrections to make to any of those documents?
I do not.
And if I were to ask you the questions in those documents, would your answers be the same?
Yes.
And are those the same answers, true and correct, to the best of your knowledge and belief?
Yes.
I attended the witness for cross.
Okay. Do you want to offer the exhibits at this point, or wait until?
Were we waiting until the end?
We can go ahead and do it now if.
I would then, for exhibits 204, 205, 214.
All right, 204, 214, and 230 have been offered. Are there any objections to their receipt? Hearing none, they will be received. Okay, for cross-examination, we would begin with legal services.
No questions, thank you.
MECG is not in the room. MIEC? Consumers Council?
No questions.
Public Council?
Briefly, were you in the room when, Dr. Mark was being cross-examined on the time of use rate?
Yes.
Do you know how the demand for Ameren's time of use rates is calculated on Ameren's website?
So based on the technical conferences that we had with Ameren, Missouri, my understanding, at that time, unless it's changed, is that it's based on an average household or average of the size. And so one of the concerns is that demand in any given month can change drastically. And demand is a new charge. Like billing on KW for a residential customer is a new concept. And so an average may not be a good picture of an average in a winter month versus a shoulder month.
And so what is the significance of that to this issue, the way this issue is being framed about the naming of these rates?
So, and the naming, and this is my understanding based on the technical conferences that we had with Ameren, is that, so the naming is ultimate savers, but my understanding is that when you go onto the website, it's being kind of marketed as an equal to all the other rate plans. So when you go to the rate comparison tool, you have all of the available residential rate plans, including this rate. And so using that average demand, and you're looking at what your bill may be, it may result in a large savings that may give the impression that a customer is wanting to go to that rate because of the large savings. But then you may go into a winter month and have a bill that's $20 higher than what you expect it to be, and the customer may be upset and wants, because not understanding that KW relationship and what can change that customer's demand in any given month, that rate may be given additional, because it shows a higher savings at the average, customers may be more inclined to pick it and then be unaware of the consequences of a later bill. So mainly with that, there needs to be more education, and maybe if you didn't advertise or display it as an equal to all of the rate plans and advertise it more as an option with a lot of additional education. and I stress education more than marketing, but education on what impacts demand. Because there's on energy, but demand is a new concept for residential customers.
Thank you, that's all I have.
Okay, and for Ameren, Missouri.
If the customer were to select a rate and then be unhappy with that, they are able to opt out, as you can, Dr. Mark was describing, right?
So it's my understanding for the ultimate savers and smart savers and, evening, morning, I'm naming out, but there are opt-outs available, but I mean, generally, I would think the goal would be to provide customers with adequate information, that they don't get an unexpected bill that causes them to opt out. But yes, to answer your question, they can opt out.
We'll move to questions from the bench, and Ms. Cleathermos is up here right now for the residential time of use rates issue. Any questions from the commissioners? Okay. I do have a question on my own behalf. And it's, does staff have concerns about the marketing for material for time of use rates in general? Or is this concern only about the names?
Well, so the names, and I think marketing, and I would encourage you to ask this question to Sarah Lange as well, because she has more extensive testimony on it.
Okay.
And so it does come into, so the naming kind of leads into the marketing issue as well, because and this from the technical conferences that we had with them where staff raised concerns with the concept, is that the marketing is based on lifestyle. So for example, like anytime users, which is the traditional historical flat rate, some customers could see that as if the blurb is, oh, if you're using energy anytime, you want this rate. So then it gives the impression that the default rate, which is where we're wanting to transition customers to TOU rates, is less favorable for them, even though it's not. And so it's going on this current lifestyle marketing plan has some, and leading to this anytime users kind of implies that the default rate isn't an adequate rate for them. And that's kind of where saying, currently the tariff for the historical flat rate is just residential basic. That's the tariff name. And so going to this anytime users based on these lifestyle categories kind of starts to confuse the rates and imply that they are better than other, which the goal is to move to TOU.
Okay, thank you. Any recross based on the questions from the bench? Hearing none. Any redirect?
Yes, Your Honor. Ms. Cleathermos, so the judge asked you about, names versus marketing and what that concern is. And were you in the room when Commissioner Roop asked Dr. Mark about, outside of names, what is something that would be Dr. Mark's recommendation? Do you have any recommendations outside of the names themselves, other than what you stated just a minute ago?
So my general recommendation, and I think this is the general recommendation of staff testimony, is to provide more education, objective names, but less marketing on a certain schedule and more education about why are the rates, different, shifting load, demand, how all of this impacts the bill so that customers can make decisions to change their load and go to TOU rates. And so more education and less focus on marketing.
No further questions.
Okay. Then you can step down, Ms. Cleathermos. And the next witness is Sarah Lange. If you please raise your right hand, do you solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? Thank you. You may inquire.
Good morning, Ms. Lange. Can you state and spell your name for the record, please?
Sarah Lynn, Ms. Lange, Sarahlinne, Quatermass, as was spelled by the prior witness, and Lange.
And how are you employed, Ms. Lange?
I am a regulatory economist with the Missouri Public Service Commission staff in the rate and tariff.
And have you prepared for filing in this proceeding certain portions of the class cost of service study report, rebuttal testimony, and surrebuttal testimony, pre-marked as exhibits 205, 215, 221, and 231?
Yes, and I believe there was also a late filed appendix to one of my testimonies. I'm not sure if that is contained within.
Yeah, that's exhibit 221, and that was scheduled for your rebuttal testimony, correct?
Correct.
Do you have any corrections to those documents?
Not that I'm aware of at this time, other than as noted in my rebuttal testimony, I believe I noted a correction to the CCOS.
And if I were to ask you the questions in those documents, would your answers be the same as corrected in the rebuttal testimony?
Yes, as of the time those testimonies were filed, with the understanding that they're all based on staff's direct revenue requirements and do not reflect the settlement position of the parties to this case.
Thank you. And are those answers true and correct at the time of filing to the best of your knowledge and belief?
Yes.
Your Honor, I would like to offer exhibits 205, 215, 221, and 231 into evidence.
All right. 205, which I believe is, has both a confidential and a public version. 215 and 231 have been offered. Any objections to their receipt? Hearing none, they will be received. And for cross-examination, we begin with legal services.
No questions.
MIEC.
No questions.
Consumers Council.
No questions, Your Honor.
Public Council.
No questions.
Ameren, Missouri.
No questions.
All right. We'll come up for questions from the bench then. Any commissioner questions for Ms. Lange?
Judge, and is she testifying just on the TOU?
Just on the TOU.
All right, no questions.
All right, I'll ask a question on my own behalf. It's the same question I asked Ms. Cleathermos, and does staff have concerns about marketing material for family of use in general, or is this concern only about the names?
As Ms. Cleaterman said, those concerns are intertwined. I think there's an overarching concern that more education can always be done and less marketing focus can always be adopted. You know, the council spoke during their opening statement, Ameren mentioned, you know, the focus groups. Well, what we heard the takeaway from the focus group was that customers don't like being told that their bill is going to go up. You know, if that is the driving force behind the materials that are being presented, then we're concerned that those are going to be misleading. Because in some cases, the result is that the customer's bill is going to go up. So, you know, we're concerned that as much transparency as possible be provided. And I agree with the comments of my supervisor, you know, to clarify that these 3 optional TOU rates are more sophisticated and are more appropriate for a customer who is interested in actively managing their bill. And that if you are a customer who is not interested in actively managing your bill, unless you just happen to be using energy as the way favored by those rates already, you will see a bill impact that you likely will not be happy with.
Now, as far as concrete proposals in this case, the only proposal staff has made is to change the names. Is that correct?
We were hopeful that during the technical conferences and settlement conferences that there would be discussion among the parties on suitable names. That is correct. We have not made formal proposals. I would agree. I think OPC threw out a color range of names, and I think they may have also thrown out, you know, residential A, residential B. Frankly, those objective, you know, residential A, B, C, D seem to make sense. or active energy managers rates, for those three more sophisticated rate options would seem to make sense. You know, I can't say, what the best names for any one of those would be, because I think that Ameren does know things about their customers and what they're receptive to and what their materials have said to date. But we just think that there's a lot of room for improvement.
And you haven't made any specific proposals for any other area of improvement other than the name changes?
Not in file testimony. We had, quite a bit of feedback during the process that, Ameren's council referred to, and, a limited amount of that was adopted. There was additional, feedback we provided at that time that, to my knowledge, has not been adopted at this point. But that was, under the workshops that occurred under the prior case docket, not in testimony in this case.
And you're not asking the commission to do anything other than tell Ameren to change the names? Formally?
I think the commission, this is an area that the commission knows a lot about and has a lot of opinions on. And I think that they have broad policy, or broad discretion in how they would, handle this issue.
I'm sure, I don't really understand your answer there.
I'm sorry, I view this as we flagged a problem.
Okay,
And we acknowledge that we don't think us and us alone can dictate the answer to this problem, but I would hope that the, commission would take into account, what it knows of the subject through this and prior cases, as well as, what the other parties have raised, as well as Ameren's responses to those other parties, in formulating the best course forward. I don't believe the commission is limited by the issue stated in the issues list, might be the more direct answer to your question.
okay. When the commission issues an order, what would you like to see in that order?
That is a very fair question for which I don't have a good answer. At this time, I think that, ordering that the parties present names within X number of days, is a reasonable answer. And I think that as far as what needs to be in the order in this case for tariff purposes, residential A, B, C, D, E, F makes most sense because they're tariff names. You know, right now they're Schedule Missouri R 1, 2, 3, 4, 5, something like that. Those names are perfectly adequate for a tariff.
Okay,
If Ameren wishes to market under different names, you know, I think that doesn't need to be handled through a tariff and can be handled through a more refined process that follows the case, or the commission could simply order that those, more sophisticated rates have added to their names active energy management rate A, B, and C, or something like that.
okay. I think I understand.
Sorry, it's not a succinct answer. I apologize.
Just trying to be clear. That's all the questions I have then. Any recross based on those questions from the bench?
Yes, from the company, Your Honor.
Yes, go right ahead.
Just to clarify, are you familiar with, on the company time of use rate plan website, that for each of the advanced rates, the overnight savers, super savers, and ultimate savers, that at the top there's a yellow flag that says advanced rate, more effort, and not verbatim, but more effort required to potentially save. Are you familiar with that?
I am not familiar with these specific colors or language. I don't have a screenshot in front of me.
Thank you. Thank you for your time.
All right, thank you. Any redirect?
No, Your Honor.
Okay. And Ms. Lange, you can step down. And the next witness then is Dr. Faruqi, who is on the telephone line. And he just unmuted, so welcome back, Dr. Faruqi.
My pleasure, Your Honor.
Thank you for waiting so patiently. If you'd please raise your right hand, I'll swear you in. Do you solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much. You may inquire.
Dr. Faruqi, please state your name for the record and spell your last name.
Yes, the name is Ahmed Faruqi, A-H-M-A-D, first name. Faruqi, F as in Frank, A-R-U-Q-U-I, last name.
behalf are you appearing today?
I'm sorry, I couldn't hear you.
Sorry, on whose behalf are you appearing today?
On behalf of Ameren, Missouri.
By whom are you employed and what is your title?
I am a principal at the Brattle Group.
You are the same Dr. Faruqi who filed direct testimony in the electric rate review case, which has been marked as Exhibit 25, correct?
Yes.
Do you have any corrections or revisions to make to your direct testimony?
No.
Are you the same Dr. Faruqi who filed rebuttal testimony in this case, which has been marked as Exhibit 73?
Yes, I am.
Do you have any corrections or revisions to make to your rebuttal testimony?
I have one correction on page 1, line 15. I want to change the word by to the word to. So with the correction, the question would read as following. Staff recommends that Ameren, Missouri increase the differential between peak and off-peak prices for the default time of use rate to 1 penny per kilowatt hour.
With that correction, if I asked you the questions in your testimony today, would your answers be the same?
Yes.
I would tender Dr. Faruqi for cross-examination, but also offer his exhibits, which have been marked Exhibits 25 and 73.
Exhibits 25 and 73 have been offered. Any objections to the receipt? Hearing none, they will be received. And for cross-examination, we begin with MECG. Legal Services?
No questions.
Consumers Council? John, did you have any?
No question.
All right. MIAC?
No questions, thank you.
For staff?
No questions, thank you.
Public Counsel?
No questions.
All right. There's no cross. Any questions from the bench?
Hey, Judge, this is Commissioner Roop. I have a quick question.
Sure, go right ahead.
Good morning, sir. I noticed that staff did make a recommendation in their testimony to make a small increase to the rated differential of the default rate. And I really appreciate them doing that. That's something that I wanted to see happen. But I'm not sure if that differential increase was approved in the settlement or not. Can you speak to that?
Actually, I have not seen the details of the settlement, so that question might be best answered by the company witness, Steve Wells.
Okay, will do. Thank you.
Okay, anything else? Any recross based on that question from the bench? Any redirect?
No.
Okay. Then the next witness is Mr. Wills. And Dr. Faruqi, I believe, can be excused.
Yes, please.
So Dr. Faruqi, you're welcome to keep listening if you wish, or you can drop off the line if you like.
I'll keep listening. Thank you very much, Judge.
Thank you. Mr. Wills, if you please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
Mr. Wills, please state your name and spell your last for the record.
Stephen Wills, W-I-L-L-S.
By whom are you employed and what is your title?
I'm employed by Ameren, Missouri as the Director of Rates and Analysis.
You are the same Stephen Wills who filed direct testimony in the electric rate review case, which has been marked as Exhibit 17, correct?
That's correct.
Do you have any revisions or corrections to make to your direct testimony?
No, I don't.
Are you the same Stephen Wills who filed rebuttal testimony in this electric rate case, which has been marked as Exhibit 18?
Yes,
Do you have any revisions or corrections to make to your rebuttal testimony?
I do. I have 4 small corrections, all on pages 43 and 44. On page 43, line 18, the second parenthetical should read, not doubling the price differential. Instead of where the word tripling was there, it should be doubling. Page 44, line 1, the word triple should be double. Page 44, line 3, the word triple should be double. And page 44, line 19, the word tripled should be doubled.
You are also the same Stephen Wills who filed rebuttal in this electric rate case, which has been marked as Exhibit 19, right?
Yes,
And do you have any corrections or revisions to your rebuttal testimony?
I do not.
With those corrections that you mentioned for your rebuttal testimony, if I asked you the questions in all of your testimony today, would your answers be the same?
Yes.
Mr. Wills is tendered for cross-examination, and Exhibits 17, 18, and 19 are offered.
All right, 17, 18, and 19 have been offered. Are there any objections to their receipt? Hearing none, they will be received. And for cross-examination, we begin with MECG.
Your Honor, it's my understanding that Mr. Wills is going to testify on class cost service issues later, and I can cross-examine him on those later.
Correct. At this point, we're just talking about the time of use rate.
No questions.
Thank you. Legal Services,
No questions.
Consumers Counsel,
no questions.
MIAC.
Yeah, I have a few questions. Good morning, Mr. Wills, how are you?
Good morning.
I just have a couple of questions about your direct testimony regarding the, SB 564 rate cap. It's in your direct testimony, page 49.
I can turn to that.
You go to 49 to 54.
Okay, I can turn to that.
Okay, so your direct testimony there, mentions that Ameren, Missouri is under rate cap because it has elected to use PISA, Plan of Service Accounting.
Ms. Plessia, is this relevant to the time of use issue? We're going to bring him back for the class cost of service issues later.
I'm sorry. Okay, no, it is not.
Okay.
Sorry about that.
Then for staff,
No questions, Your Honor.
Public Counsel.
Just a few. I'm just I want to get an understanding of how many customers have already opted into the time use rate. I know some numbers were given earlier. Can you provide how many now have opted into?
Sure. And this is as of this morning, I checked our dashboard that we, monitor that. There's a total of 548 on the 3, what we're calling advanced rates, the overnight savers, smart savers, and ultimate savers. 248 are on the overnight savers, 157 are on the smart savers, and 143 are on the ultimate savers, as of our dashboard this morning.
Okay. I guess I heard some numbers in your council's opening about 100,000. I'm not sure what that was referring to.
That's the default time of use rate that customers are transitioned to. That's 6 months after having an AMI meter. We call that the evening morning savers rate. And as of this morning, there's actually 201,474 customers on that.
Okay. And then Ameren has over 1 million customers residential, is that correct?
That's correct.
And is the goal to transition all customers to a time of use rate?
No, the goal is to give those customers choices themselves to determine what rates are best for them, but we do believe that there's a significant number of customers that will appreciate the opportunity to manage their energy bills and will want to avail themselves of those time of use options. Certainly those that don't make another election will be transferred to the evening morning savers rate, which is the company's new default rate as established in the last rate case.
Thank you, that's all I had.
All right, then we'll come up for questions from the bench. Commissioner questions?
It's Commissioner Root.
Yes.
Yeah, same question I had for Mr. Faruqi. Basically, staff had recommended a small increase to the differential rate of Ameren's TOU, default TOU rate. but I have not been able to figure out if it made it into the settlement. Can he speak to that?
Sure, yeah, no, the settlement believes that the differential on the default rate, the same as it has been previously.
That's disappointing.
So
But
I
thank you.
understand.
But thank you for your answer.
Sure, I think, Commissioner Roof, I think I would just say, our main concern is stability really in what we're communicating to customers while customers are in the transition process. So that's, with the small increase in differential was not really a significant price signal change, but it was what we viewed as, a change that would potentially kind of, cause confusion and disruption to customers that were getting communications about it. So I understand your position. That's just kind of what led to that outcome.
Because you believe that customers are examining everything down to a few decimal points, and that would cause them confusion to which they would not participate.
I think that for those who are paying close attention, it would cause confusion. I don't think, the average customer probably would notice it, but I do think there are those who pay very close attention and that they would, have good reason to question why some of the bill impact estimates might have changed on them.
I understand. I would argue that those that are actually paying attention would probably applaud that change, but that's just my opinion. But thank you for your answer.
Sure.
Thank you. Anything else from the commissioners? Anyone wish to recross based on that question from the commission? Seeing none. Any redirect?
Yes, briefly, Your Honor. Just to clarify for the record, Counsel for OPZ had asked you some of the current data, but I don't believe that you mentioned the anytime users count. How many are on that existing flat rate?
Well, certainly anyone that doesn't have an AMI meter or has been on the AMI meter for less than 6 months and hasn't opted into a rate is on that. So that's hundreds of thousands of customers that I don't have that exact number. But of those who have gone into the kind of rate communication process and have had an AMI meter and have the option, and this is not as of this morning because I didn't have that on the dashboard, but as of last week, 29,732 have returned to the pre-existing flat rate.
Thank you. Thank you, Your Honor.
Thank you. And Mr. Wills, you can step down. And I believe that completes issue 17 about the residential time of use rates. That leads us then into the other issue for today, the class cost of service revenue allocation and rate design issue. And I note that there are multiple sub-issues on this with the same witnesses listed for each one. Do the parties want to call everybody up at one time, or should we do each sub-issue separately?
That would be the company's preference as well. Do it all at once, please.
Okay.
Staff's preference as well.
Okay, then the first witness then would be Steve Wills again.
Your Honor?
Yes.
I was hoping to make a motion to have my witness, Jackie Hutchison, waived in the hearing. She really didn't address much in this area. And I've asked the parties who are here if they have any questions, and I haven't noticed anyone that did. But I wanted to give the commission an opportunity. If they have questions, we could certainly make her available, but otherwise I would move to have her waived.
Okay, let me ask the commissioners on the line. Does anyone have any questions for Ms. Hutchison?
No, Judge.
All right. Then she can be excused. When it comes time to her, we'll just go ahead and you can offer her testimony and with that waiver in process.
Appreciate it. Thank you.
Okay. All right, Mr. Wills, you're still under oath.
Okay.
Direct again.
You have previously stated your first and last name for the record. Would you spell your last name again?
W-I-L-L-S.
And you're the same Steve Wills who testified earlier in the evidentiary hearing about issue number 17A. Mr. Wills is tendered for cross-examination.
Okay. And for cross-examination, beginning with MECG.
Thank you, Your Honor.
Good morning, sir.
Good morning.
You are the Ameren witness that testified on rate design, is that correct?
Certain rate design issues.
Okay, you were the Ameren witness that testified on the SGS LP rate design issues, is that correct?
Yes, that's correct.
Okay. Are you familiar with the concept known as hours use rate design?
Yes, I am.
Okay. In your most simplified fashion, can you explain how the hours use rate design is calculated?
Sure. It's a block rate, like we have block rates in other classes, except for the size of the energy blocks that are applied to pricing are a function of that customer's demand. So if you have a higher demand, you have a higher block threshold. And if you have a lower demand, you have a lower block threshold. So as you use energy, it proceeds through those prices more quickly if you have a higher demand level.
Do you believe that most customers in the LGS and SP classes understand the hours use rate design?
I mean, I can't speak for all customers. I think that there's probably a significant number that don't understand fully that rate design.
Okay. Does the customer bill to these customers in these classes, do they reflect the amount of usage that the customer is priced at in each of those blocks?
I haven't reviewed it just coming into this morning. I believe it does, but I would have to actually look at a bill to be 100% certain.
So in order to price it out independently though, a customer would have to know how to derive the amount of energy that they use that is associated with each kW of demand. Is that correct?
Yes, there's a relationship inherent in it between demand and energy. So yeah, you'd have to know that relationship and able to develop the rate blocks and then the bill.
I'm sorry, develop?
The rate blocks for the bill.
And given your testimony, the company believes that there are more simplified rate designs possible for these industrial classes. It's just a matter of how soon it should be implemented and waiting until after AMI is fully deployed. Is that correct?
Yes, I think there are certainly more simple rate designs. I think for them to be simple and cost reflective, it would be most beneficial to have AMI data in its entirety. So we can use more sophisticated, either time variation or things like that, which wouldn't be possible with the legacy meters necessarily. But I mean, so in general, yes, I agree with what you said.
And when do you anticipate that AMI will be fully deployed for LGS, SP, and LP classes?
I believe it's scheduled to be subject to, meeting that schedule around the end of 2024.
Okay.
So going into 2025.
Okay. No further questions, Your Honor. Thank you.
All right. For legal services,
No questions.
Consumers Council,
No questions.
MIAC.
Yeah, I'll pick up on the line of questioning that I accidentally started before. So for that again, we were talking about the rate set testimony that you have, and you're correct, starting on page 44. I'm sorry, 49.
Okay, I'm back to that.
Okay. So in your testimony, you talked about the rate caps that are included in Senate Bill 564, and those rate caps apply to residential customers. They apply to all customers, but there are two different caps. There's one of 2.85% for residential customers and a subcap of 2% for large primary customers. Is that correct?
Well, I would say the 2.85% applies to all customers, not just residential, but the entirety of the customer population, and then the 2% specifically to our large power class, which is large primary service 11M.
Okay. And do you think that either of those caps will be hit by any rate increases?
No, I do not.
All right. For staff,
No question.
Public Counsel.
No questions.
All right. Let's come up for questions from the bench. Any questions, commissioner questions for Mr. Wills? All right, not hearing any, but I do have a question, and it's kind of a general question. For these classes, we tend to use acronyms and so forth. For each of the rate classes that are involved here, can you tell me what kind of customers qualify for that rate in that rate class? And can you give me a sample of, or example of a customer who would fall within that?
I'll do my best.
Okay.
I think hopefully residential is pretty self-explanatory. Small general service is any commercial or industrial, really any non-residential account that the maximum demand is under 100 kilowatts. So basically it's going to be your smaller commercial and industrial customers, you know, small offices, small retail outlets, you know, just any, basically small business. The large general service is customers that still take service at secondary voltages. So that's really the defining difference between large general service and the other classes. It's also commercial and industrial customers, but they're going to be those that have a demand above 100 kilowatts. So a little bit larger businesses, like you probably see maybe at grocery stores or other, you know, larger chain stores. You know, you're going to see larger office buildings.
If I can ask you to clarify something for me, you've been using the term demand above 100 kilowatts. What does that imply?
So, you know, 100 kilowatts, I'm trying to give you a good reference point. I mean, you know, a home, very, very rough estimate of a home would maybe have 5 kilowatts of demand. So you're talking about the size of 20, you know, the amount of usage of maybe 20 homes or something like that. Is that helpful?
That is, and are we talking about kilowatt per hour or how?
So it's a demand measurement. So demand is, you know, can be measured over different periods of time. For purposes of these delineations between the rates, it's measured over an average over 15 minutes.
Okay.
So if you ever spend 15 minutes where you're averaging drawing over 100 kilowatts, then you would fall into that next rate classification.
Okay, thank you. And I interrupted you when you were explaining all the other rates. Go back to that, please.
Okay, so then we go to the 4M small primary service. Those are customers that take service at higher voltages than the large general service, but from a size threshold, they could be similar size. There tend to be a little bit more industrial customers in that class that are taking a primary service, but there certainly could be things like hospitals sometimes fall into that class. Other larger commercial and industrial businesses that are significant energy users that may be taking primary voltage service. And then our 11M rate is large primary service. And again, those are taking, you know, service at higher voltages, but they're also the largest users. They're over 5 megawatts of demand, so that's 50 times the 100 kilowatt threshold we talked about previously. You're looking at larger industrial customers, very large, like maybe very large hospital or university complexes. There are some commercial and industrial customers, but they tend to be very large energy users at that point.
Okay. That's all the questions I had then. Anyone wish to recross based on those questions from the bench?
Yes, Your Honor.
Let's go Mr. Kaufman first. I'm sorry, MECG first.
Just one question. You're familiar with the rider B issue that's been talked about here?
Yes.
Okay. Given the definitions that you just gave to the judge, is the rider B issue only applicable to customers that take service at primary voltage, so the SP and the LP classes, or could it apply to others?
It's just an issue for the primary service classes, 4M and 11M. Thank you.
Okay, Consumer Counsel?
Yes, my question is even more basic, and this is just for the purposes of general understanding, because it's confusing to many folks. Could you, when you were talking about energy demand, could you give just your basic definition of what energy demand is in contrast to energy usage?
So demand is like the rate of usage. So I think maybe one of the better analogies that I've heard is comparing it to like water flow. If you were turned on a faucet, the amount of water that is passing through the faucet at any given time is like the demand And if it's accumulating in a bucket or a basin or a sink, the amount of water that accumulates is equivalent to like the energy. But it's a rate of usage versus an amount of total consumption or usage.
That's good, I hadn't heard that, thank you.
Sure.
And I believe staff wanted to cross?
Yes, so would an SGS also include a residential outbuilding such as a detached garage?
It could, yes.
Okay. Public counsel?
No questions.
All right. Any redirect?
Just briefly to clarify, you didn't describe the lighting classes. Can you specify those for the bench, please?
Yes, I apologize for that. We have two different classes of lighting service. One is our 5M rate, which is company-owned lights, and for those customers, we actually supply the light fixtures themselves, as well as the energy. And then we have the 6M customer-owned lighting rates, in which case the customers own the fixture itself that creates the light, but we just provide energy to those lights.
Thank you, that's all I had.
I have one more clarifying question, and it's about your last response about the customer lighting. Was that resolved? Was there a resolution to that issue in the stipulation and agreement?
No.
No. Okay.
No, that's part of, just the class allocations. So those classes are still subject to the determination of the revenue allocation.
Okay. Thank you. I guess I'll offer anybody that wants to recross based on that question again. I don't see any redirect on based on that. No. All right. Then Mr. Wills, you can step down. And then the next witness would be Thomas Hickman for Ameren. Good morning. If you please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may inquire.
Thank you. Mr. Hickman, please state your name for the record and spell your last name.
My name is Thomas Hickman, last name is Hickman.
By whom are you employed and what is your title?
I'm employed by Ameren, Missouri as a regulatory rate specialist.
You are the same Thomas Hickman who filed direct testimony in this electric rate case, which has been marked as Exhibit 30, right?
Yes.
Do you have any corrections or revisions to make to your direct testimony?
I do not.
Are you the same Thomas Hickman who filed rebuttal testimony in this case, which was marked as Exhibit 31?
Yes.
And do you have any corrections or revisions to that rebuttal testimony?
I do not.
If I asked you the questions contained in your testimony today, would your answers be the same?
Yes.
Mr. Hickman is tendered for cross-examination, and I would offer Exhibits 30 and 31.
30 and 31 have been offered. Any objections to their receipt? Hearing none, they will be received. And again, for cross-examination, we would begin with MECG.
Thank you, Your Honor. Good morning, sir. Good morning. Do you have your direct testimony in front of you?
Yes, I do.
Could you turn to page 19?
I'm on page 19.
And the question and answer that starts on line 9 of that, would you read the last two sentences aloud? Starting with a cost allocation.
I'm sorry, which lines?
Well, it's on lines 19 through 23.
Okay. Starting with the sentence on 19.
Yes.
A cost allocation methodology that gives weight to both class peak demands and class energy consumption, in parentheses, average demands, is required to properly address both of the above considerations associated with capacity planning. The A&E methodology gives weight to both of these considerations by its inclusion of both average and class demands, which are kilowatt hours divided by total hours in the year, in parentheses, 8,760 hours, and excess NCP demands of each class.
Thank you. So what you're saying there is a fixed production cost allocator must you use the word required, must consider both, demand and energy, is that correct?
I would say that there are allocators that don't consider both, but I think that the impact of both should be considered when selecting one to use. So said another way, a strictly coincident peak may not consider energy, but I think in deciding whether to use coincident peak, you should consider energy as well.
Okay.
Does that make sense?
And so the A&E version that you use considers both of those, is that correct?
Yes.
And you applied the A&E methodology to not only fossil units, nuclear units, but also renewable units, is that correct?
Correct.
Okay. I'm going to hand you a document, and I don't need to mark it as an exhibit. I'll show it to your council first. I'm going to hand you a document and ask you first if you can identify that.
It appears to be rebuttal testimony of Will Cooper in the 2010 electric case.
And can you turn to the page? I didn't even mark it on mine. I have a sticky note there, and can you tell me what page that was on?
Page 5.
Okay. You turn to that and read out loud the provision that I have highlighted.
Objection, hearsay, and inability to cross-examine Mr. Cooper.
It is the company's position. It's not so much just Mr. Cooper's position, but the company filed it. So I'm going to ask him whether he, as the Ameren witness in this case, agrees to that.
Okay, it sounds like it's not being offered for the proof of the matter asserted, so it's not hearsay. You can proceed.
Would you read aloud the section that I've highlighted?
Yep. Sure. The question is, the company and MIEC have proposed the use of an A&E method for the allocation of production plant investment, while staff in one of OPC's allocation methods proposes the use of the peak and average method. Please comment on the use of the A&E method versus the P&A method for the allocation of production plant investment. And the answer reads, the use of P&A method is inherently flawed as it double counts the average demand of customer classes. This double counting results from the previously described use of class average demand for a portion of production plant allocation, in parentheses, i.e. the 55% system load factor weighting piece, in parentheses, in the use of class peak or non-coincident peak demands, which include an average demand component for the remaining allocation of production plant, in parentheses, i.e. 45%, in parentheses. This double counting results in customers with higher load factors being allocated an inequitable share of production plant investment. This result is driven by the high load factor customers, demonstrating a better correlation between average demands and peak demands than do lower load factor customers. Therefore, higher load factor customers receive a disproportionate share of the non-average demand, in parentheses, i.e. 45%, in parentheses, portion of production plant investment.
Thank you. Do you agree with Ameren's testimony from that 2010 case that the peak and average double counts class energy usage?
Yes, I do.
Okay. No further questions. Thank you.
Okay, then for legal services.
No questions, Your Honor.
Consumers Counsel.
No question.
MIEC.
No question.
Staff.
Yeah. How many total kilowatts of capacity does Ameren, Missouri have?
Total kilowatts of capacity. I don't have that number offhand.
How many accredited MISO kilowatts of capacity does Ameren,
I also don't have that number offhand.
Do you know what reserve capacity is required for Ameren, Missouri?
Again, I don't have that number from me now.
And do you know what the accredited capacity of Ameren, Missouri wind is? Do you know what the total capacity of Ameren, Missouri wind is?
I do not.
No further questions.
Okay, any questions from the, moving up for questions from the, or I'm sorry, public counsel first. Moving up for questions from the bench. Any commissioner questions?
Hey, Judge, it's Commissioner Roop. I lost a little bit of audio there. Can you confirm who's on the stand?
This is Mr. Hickman.
Okay, great. Yeah, I have a quick question.
Go ahead.
So Ameren has argued that staff's method of allocation production cost is inconsistent with section 393.1620 that was passed in the legislative session just recently. Can you speak to why why you feel that is consistent, and why you guys feel it was okay to use and kind of combat staff's argument?
I just want to be clear, I understand you, Commissioner. You're talking about production allocations?
Yes, production cost, yes.
I don't believe my testimony intended that staff's production allocations were not allowed under the statute. I think that my understanding of staff's approach was that they showed a range of possible outcomes, and within that range, all of the potential outcomes that would have been allowed by virtue of this statute allowing the use of the narrative manual were included for consideration.
So do you believe that the principles that staff used from the RAP manual are appropriate in the production costs?
I think it's difficult to answer that specifically because, again, they've provided a range of possible outcomes. My recollection is that they didn't state a specific outcome as the outcome they were using. They used one of the outcomes, one of their options to illustrate some graphs and illustrations, but I don't recall a specific outcome being proposed as the outcome.
Okay, and so from looking at it, it looks as if staff only used the RAP production allocation principles just for renewable resources, but the law says also for nuclear and fossil fuel. Is that how you viewed that they did not apply it to the others?
Can you repeat that? I'm sorry.
So the way I've interpreted and the way I've read what staff has done is they only used the they only used the RAP production allocation principles for renewable resources. But when you go back and look at the statute, it also says for nuclear and fossil fuel generating units.
I would confirm that my understanding of the statute is that it only applies to those and it doesn't apply to the other renewable sources. So the way in which they allocate those per the statute would not be limited to the narrative manual. I do believe there's a little, I mean, they proposed different options, and again, they didn't, state to have followed one specific option. But my understanding is that the peak and average method is not a method outlined in the NARIC manual. But again, the question you're asking me is a little bit tough because in my opinion, staff didn't propose one single answer, right?
Okay.
Not confusing or muddying the water. But to the question that you were asking in terms of the applicability of the statute, my understanding is that it only applies to nuclear and fossil, correct? And that the other sources of generation are not covered by the statute.
So would you say that the company's position is that staff's method was not consistent with section 393.1620?
I would not say that. And again, part of the challenge is that multiple options were proposed. And so options that were consistent with the statute were proposed. I wouldn't allege that staff didn't follow the statute.
Okay, thank you. That cleared up. Thank you.
Anything else, Commissioner?
For this one.
Okay. I have a couple of questions. Specifically, this one is about subsection F, which is MECG's proposed shift to increase the demand component for large general service and small primary service. I believe Ameren, Missouri expressed some concern about the possible impact of that shift on its efficient electrification program. Can you explain that? What Ameren's concerns are?
I think that question would be better answered probably by either Steve Wills or Mike Harding. My testimony was more about our cost of service and the results of the cost of service don't necessarily tell what to do with a specific demand charge or a specific rate.
Okay, I'll save it for Mr. Harding then.
Okay.
And then the other question is about subsection G. That's MECG's recommendation to require the company to present analysis of alternatives to the hours use rate design. And Ameren's position was that it should wait until after the rollout of the AMI meters is completed. Again, this maybe it's a question for somebody else, but why is the AMI data needed to redesign rates?
I think it would be better to ask another one of our witnesses, but I think, you know, just generically, I understand it that, you know, more information is always better, and so we're going to get considerably more data out of the AMI technology than what we got out of the AMR technology, and so any extent of increased or more accurate data that we have could lead to, you know, better determination of the timing of price signals and things like that. But for, you know, a better, more complete answer, Mr. Wills or Mr. Harding would probably be a better source.
Okay. Then my final question is about subsection H. Just in general, staff's concerned that they didn't have enough information from Ameren, Missouri. Is this a question for you, or would this be another one for Mr. Harding?
I probably would be the right one for this.
Okay. Do you understand what staff is asking for as far as additional information?
If I may, I thought that H was how, oh, sorry. I thought that was regarding the distribution for customer classes.
That's right. Well, I'm not sure exactly where this question falls under then. It may be H or it may be I or J. It's kind of general. It crosses over the various issues. But if you can go ahead and answer.
I'm sorry, can you repeat that?
Okay.
Sorry.
Staff has indicated that they would like to have additional information from Ameren as far as assignments or of various costs. do you understand what staff is asking for? And then the next question is it possible for Ameren to be able to give it to them?
I think that's a difficult question to answer, because I think there's different things that are being asked for. You know, as I sit here today, I think some of the things being asked for make sense, some of them maybe not as much. It's not just one singular thing I feel like is necessarily being asked for. And a significant portion of what has been requested is not information that the company has and is just sitting there readily available to be produced. It's conceivable that a certain amount of effort or undertaking could be taken to answer some of the questions. Some of the questions go really broad in scope and require information, you know, on where specific distribution assets are located for us to answer. And, you know, due to the nature of mass property, do we know exactly where every pole is located on the system? Generically, yes. Do we know exactly what size conductor is connected to every pole? That's not within our databases. That's a really big ask in terms of data.
Okay. I think that answers my question. So based on, recross based on questions from the bench?
Yes, Your Honor.
Go ahead.
Mr. Hickman, going to that last question from the bench about distribution costs. Can you tell me what the difference is between assignment and allocation?
Sure, I can tell you my best understanding of what the differences are in interpretation. I think allocation is trying to look at a subset of cost drivers and kind of come up with some allocations that could be applied more broadly to an entire balance of an account. So, you know, generally, how are these assets used? What percentage of these assets are used by which customers, which class? And then you apply it to an entire balance, right? Direct assignment is, in my opinion, considerably more specific. I know there's been some discussion in terms of what exactly is being asked for and what assets, but for example, to identify the exact poles leading up to a large primary customer and to identify the cost of those exact poles and allocate them to the class based on the fact that that customer is benefiting from those poles is kind of how I view direct assignment. You're trying to identify the exact assets that are used by that customer, either the exact costs or a proxy of those exact costs, and apply it to that customer.
In your response to the judge's question, you mentioned the words mass property accounting. Do you recall that?
Yes.
Can you tell me what mass property accounting is?
So I'll admit that I'm not an accountant, but I can give you my general understanding of it. So mass property is how a lot of distribution accounts or distribution assets are accounted for. In the basic gist of it is, if we had to account for every single 40-foot wood pole that the company owns separately and depreciate them all separately, that'd be a lot of data. We'd have to know exactly where they're located. When we take a 40-foot wood pole out of service, we'd have to know exactly which pole's taken out of service, right? Because you have to make a entry that would produce accumulated depreciation and everything, and it's on that one specific pole. Mass property allows us to account for all 40-foot wood poles on more of an average basis.
Yeah, in there.
In that process, specific location of those assets is not required because, again, you're not tracking that that's the exact 40-foot pole that was retired. In mass property applies to a couple of the different distribution accounts, poles, conductors, transformers.
In the rate-making process, the class growth and service process, is it true that we are setting rates for, if you will, the average customer within a class? We're not setting rates for a specific customer that's served by X pole, by X transformer, by X substation. Is that correct?
Yes, I would agree with that.
Okay. No further questions. Thank you.
Anyone else wish to recross?
Yes, Your Honor.
All right, for staff.
Staff has not asked actually for a location of every pole and wire, is that right?
Yes, I would agree with that.
And earlier, Commissioner Roop was asking you about the average and peak method and the neighborhood manual. Do you recall that?
Yes.
And you could agree that, there are average and peak method variations discussed in the 1992 neighborhood manual.
I think without having an exact definition for what peak and average is, that yes, there are a variety of different methods outlined in the neighborhood manual. Yes.
Okay, so average and peak is not defined in the statute, is that right?
Not specifically, no.
And is average and peak defined in the 1992 neighborhood manual?
I don't have the manual in front of me to seek out a specific definition, no.
No further questions.
All right, any redirect?
Just briefly, Your Honor, when you were discussing data collection or retention with the judge here, he was asking about additional information. The company, though, has agreed to provide some additional data collection under the stipulation in this case, have they not?
Yes.
Okay. Thank you very much.
Thank you. And with that, you can step down. And it's now 12:02, so it's time to break for lunch. Let's come back at 1:15.
Sure.
I worked with her over at, Jefferson. Is she still around town then? What's she doing now?
I don't know about her. It was really fun to see their old house. We had a daughter, Elizabeth. Number 11. 2 months after. The other was the Starbucks. First one. So she was getting diaper ads in her mail, and we were getting like nursing school applications in our mail, and we were like.
Schools get accredited, every parent in that school gets surveyed. So kids, the parent has 5 kids, they get 5 surveys. A survey or 2 surveys for each kid in the school. They each come back to them in their own school. So our job as interns, to open each of those manila envelopes and lay out the surveys flat, and then she would run them through the Scantron.
At least you guys.
Yeah. But the fun thing that would happen at least once a week, though, you run them through the opening machine, and then you go, to smooth up the stack, and you get paper cuts from each one of the envelopes across the town, 500 in a stack, you get 1,000 paper cuts, depending on the move.
Okay, it's 1:15, so let's go ahead and get started again. Welcome back from lunch. The next item would be, next witness is Michael Harding. Is he here?
Just walked in.
Just walked in, okay. And if you please raise your right hand. Solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth. Thank you. You may inquire.
Thank you. Mr. Harding, please state your name and spell your last name for the record.
Michael Harding, Harding.
By whom are you employed and what is your title?
Cameron, Missouri, manager of rates and analysis.
You are the same Michael Harding who filed direct testimony in the selected rate case, which has been marked as Exhibit 44, correct?
Yes.
Do you have any corrections or revisions to your direct testimony? No. Are you the same Michael Harding who filed rebuttal testimony as well, which has been marked as Exhibit 45?
I am.
And do you have any corrections or revisions to Exhibit 45?
No.
If I asked you the questions contained within your testimony today, would your answers be the same?
Yes.
Mr. Harding is tendered for cross-examination, and I would offer Exhibits 44 and 45 into the record.
All right, 44 and 45 have been offered. Any objections to their receipt? Hearing none, they will be received.
If you could use the microphone. I mean, I can hear you okay. I'm concerned about the people on the phone.
And feel free to move it a bit closer to you if you need to, if you can. I think so, yeah. Okay. For cross-examination, begin with MECG.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
You have your direct testimony in front of you.
I do.
Would you turn to page 5 of that testimony?
I am there.
Okay, and at the top of that page is a table 2 entitled cost-based rate changes by customer class. Do you see that?
I do.
Would you agree that what that table shows that under Ameren's class cost of service study, LGS SP rate classes are currently paying rates above class cost of service?
Yes.
And that can be shown by the fact that while at this time you were requesting a 12% rate increase, the LGS SP class should only receive a 1.4%
to, achieve exact class cost of service for the, Ameren study, yes.
And that, similarly, at that time, when you were requesting a 12% rate increase, the residential class, in order to achieve class cost of service, would have needed a 20.4% rate increase. Is that correct?
That is correct.
And the rate increase agreed to under the stipulation was 8.81%. Is that correct?
I believe so, yes.
Okay. And so to put this table on a basis taking into account that reduced revenue requirement, is it fair then the difference between 12% and 8.81 is minus 3.19%? So the 20.4% for a residential class would now have to be reduced by roughly 3.19%?
That sounds right.
Okay. Now turning to page 6. Table 3, do you see that?
I do.
Okay, so again, at this point in time, you were showing a rate increase of 11.93%. Do you see that?
I do.
And even then, for the LGS and SP class, you were recommending an increase above that of 11.96 and 11.98% respectively. Is that correct?
That is correct.
Okay, so at a time, you said on the previous page that those classes are already paying rates above class cost of service. You're recommending here an increase above the system average. Is that correct?
Above what the equal rate of return class cost of service, solely that, has recommended changes to achieve that, yes.
Okay, so the fact that you are recommending an increase above the system average, wouldn't that exacerbate the subsidy inherent in their rates?
Not necessarily.
Explain that.
Well, it's a snapshot, so the class cost of service is a snapshot in time. So there's lots of factors when you take that snapshot that could change. It's definitely in line with, I think, past settlement that all parties agreed to. I think it's definitely in line with past commission orders to have that equal rate percentage. Obviously, as we've heard here many times, there's lots of different factors beyond class cost of service that are considered. I would say this a very important factor, not one of the most important factors, is our basis for setting.
Okay, so you say we're talking about things snapshot, that things can change. Would you agree that it is not consistent to give this class an above system average increase? It's not consistent with your snapshot class cost of service study?
I think it's consistent, though, with what all parties have agreed to in settlement.
That's not what I asked you. Is it consistent with your snapshot class cost of service study?
It is not a move. It does not mirror what our equal rate of return class of service recommends to go exactly to cost of service, correct?
It doesn't mirror it, but it doesn't even move in the right direction. This moves it up, whereas the class cost of service snapshot would say they should get less than the system average.
Agreed.
Okay. To the residential class now. You said on table 2 that the residential class are paying rates that are. Is that correct?
Yes.
Okay. And according to table 3, while you're looking at an overall increase of 11.93% increase, you propose to give the residential class only 11.90%. Is that what this shows?
Yes.
So again, your recommendation regarding the residential class is not consistent directionally with the results of your snapshot class cost of service study. Is that correct?
No, it's consistent directionally. We're showing in our equal rate of return class cost of service study that the residential service is underpaying the cost of service, and that we're recommending an increase for that class as well.
But you're not recommending an increase. Your recommended increase is below the system average.
Oh, as you refer to system average our equal rate of return class cost of service. Yes, that is correct.
Okay, so just to clear up, 'cause
Yep.
your recommendation for revenue allocation for the residential class is not directionally consistent with the results of your class cost of service study.
Well, when you say directionally consistent, I would say that it is, but maybe we're talking past each other. The equal rate of return class cost of service shows that the residential class is underpaying, and they need an increase in rates, and that's what they're receiving through our direct recommendation of an increase in the rates.
But you're proposing an increase in residential rates that are below the 11.93% overall rate increase.
Oh, you're referring to the 0.03% difference?
Yes.
Okay, yes, it's 0.3% lower than the entire amount.
Okay. I think that was all I had to say, sir.
All right. And for legal services,
No questions, Your Honor.
Consumers Counsel.
Yes, I have a couple. Good afternoon. I'm John Kaufman at Consumers Counsel, and I was wanting to follow up on the questioning that you had from Mr. Woodsmall. To the degree that there is a differential, I guess, from Mr. Woodsmall's perspective, as a subsidy, is there any reason to believe that that differential will grow between now and the next Ameren rate case, or is it also likely that that might go the other direction?
That's hard to say. I don't really have a great study or anything to point to or to refer to project how those dynamics could change.
There's nothing in your testimony in this case that would suggest that any differential between rates and your company's class cost of service study results would grow or shrink either way. It is just a snapshot.
That's correct.
And were you involved in the previous Ameren rate case?
Yes,
Which was a rate decrease case, correct?
that is correct.
And did the large customers in that case receive a larger rate reduction on a percentage basis than the residential class? Or some classes?
Did the residential customers?
Did the residential customers receive, was it an equal percentage rate reduction in that case?
I don't have that in front of me, and I believe we did, but honestly, without that in front of me right now, I couldn't say for sure.
Well, I guess I can't ask you my next question. Thank you.
Okay, for MIC,
No questions, thank you.
for staff?
Yes, thank you, Your Honor. Do you recall Mr. Woodsmall asking you to subtract 8% from 12%, and I believe it was table 2 of your testimony?
Something to that effect, yep.
That was based on, that table was based on Ameren's proposed revenue requirement increase, correct?
Yes.
And is Ameren's proposed revenue requirement, I guess now stipulated revenue requirement increase, is it mostly related to fuel expense, rate of return, depreciation rates, production capacity, or some other factor?
That's a better question for accounting. I don't know.
And do you know, so the costs and other expenses, fuel expense, rate of return, depreciation, production capacity, are those allocated evenly among each class in the Ameren class cost of service study?
Allocated evenly. Which inputs, did you say that again? Could you rattle those off?
Yeah, fuel expense, rate of return, depreciation rates, production capacity.
Well, I know that at least one of those, right, the equal rate of return class cost of service study that you're referring to there, table 2, in order to perform that study, the rate of return is equal in sets all classes. So I can answer that one. on the other side, I'm not quite sure.
Okay. Now what about rate base? Is rate base equally allocated among all, classes?
Well, no, it's dependent on that equal rate of return that I just mentioned to you is applied against that.
So the, if the rate base is not allocated equally among all classes, then the rate of return associated with that rate base won't be equally allocated among all the rate classes. Is that right?
I'm sorry, equally.
Equally allocated among the rate classes.
Could you restate that? I'm sorry.
Yeah, I'll go back and, one back at a time. Rate base, is not equally allocated equally among all the classes.
When you say equally, I would say it is. It's from a rate of return perspective, it is.
Okay, so the rate base per kilowatt or per kilowatt hour is not the same for all rate classes?
The rate base per kilowatt hour is not the same for all. No.
So, just to be clear, when I'm talking about, evenly allocated, I'm talking about the rate of return on rate base. So say, for example, if more rate base were allocated to, one class, then the rate of return that goes with that rate base would go with that rate class, right?
That sounds right.
In dollars.
Okay. I think so. I think I'm tracking with what you're saying.
No further questions.
Public counsel?
No questions.
All right. Well, for questions from the bench, any questions from the commissioners for Mr. Harding?
No, thank you.
No
Judge.
questions, Judge.
Okay. I do have a couple questions that Mr. Hickman kind of deferred to you. The first one is about sub-issue F. Ameren expressed some concern that the proposed shift by MECG to increase the demand component of the rates would have a negative impact on efficient electrification program. Can you explain what that impact might be?
I think he was referring just to the shift away from energy to
Yes.
capacity primarily, and that there would be less incentive to reduce kilowatt hours if more of the charge and more of the billing units were placed into KW or capacity or demand charge.
Okay. Would that imply then also an increased interest in reducing capacity? Or is that part of electrification?
I think it would increase, people's desire to reduce their demand charge and find ways to reduce their demand charge.
Okay.
If you shift from the energy into the demand charge.
And is that something that would be beneficial for Ameren system?
I do think that is beneficial.
Okay. The other question is in subsection G, and that's about the Commission's approval of MECG's recommendation to require the company to present analysis of alternatives to the hours use rate designed by 2025. And Ameren's position was that it should wait until the rollout of AMI meters is complete. Can you explain why AMI data is necessary to your efforts to reconsider or redesign the rates?
I think it's just greater granularity and data available to, have the options to, for perhaps more intelligent designs that better assign cost to cost causers. It just gives you more optionality. And it will be a little easier to roll that out once we have full adoption and we can, implement that as opposed to trying to, work with our software teams to have two systems at like the same time trying to track the data.
And full adoption's planned for 2025?
That's my understanding.
Okay. That's all the questions I had. Are there any recross based on those questions from the bench?
Yes, Your Honor. I sensed that the record wasn't clear when you were talking about the MECG proposal on rate design, and maybe I just heard it wrong, so I wanted to kind of clarify some of that. Is it your understanding that the MECG proposal for the LGSSP class would be to move more cost into the demand charge, taking cost out of the energy charges? Is that correct?
Solely within that class, yes.
Okay. And that electrification will be incented by higher energy charges. Is that correct?
You're saying that, will that shift incent electrification through higher energy charges?
No, I'm trying to get, and I think the problem here was this was all in Mr. Will's testimony, so it was all dumped on you. But companies and parties will have a greater incentive to undertake electrification if energy charges are lower. Is that correct?
I would say no. I'd say when energy charges are higher.
Okay, I'm sorry, yeah. If energy, if energy charges are higher, parties will have a greater incentive to engage in electrification.
Absolutely.
Okay. And the MECG proposal to move costs out of the energy charge will reduce the energy charges. Is that correct?
Yes.
Okay. So the lowering of energy charges will decrease the incentive to engage in electrification.
Possibly.
Okay. And that is just a theoretical argument. That is not an argument that's based on class cost of service. Is that correct?
I'd say that's fair, yeah. You know, we don't know what different businesses, models and thresholds have for investing in efficient electrification. But it's fair to say that there, you know, depending on the shift, there could be some companies that no longer find it appealing to maybe make those initial investments where it just solely reduces energy costs.
And here's the point where I'm going to. In his direct testimony, Mr. Chris stated, based upon the company's class cost of service study, that the energy charges are inflated right now. The demand charges are depressed. Do you have any reason to doubt that?
From our class cost of service study, they look pretty close in line. For example, the distribution demand charges, I believe there's 114 approximately million allocated distribution demand between the 3 and 4M classes. And after the settled proposed amount is allocated to the demand charges between 3 and 4M, I think the amount was approximately 100 million. So the difference of about, talking about a difference of about 14 million, which I wouldn't characterize as way out of whack for, you know, allocations and using the class cost service model to approximate where rates should be.
Do you have Mr. Chris's direct testimony in front of you?
I do not.
Okay. Do you have any reason, given all you just stated, to question Mr. Will's conclusion that MECG's rate design proposal is directionally correct?
I would agree it's directionally correct.
Okay, so it is directionally correct to move more cost into demand and take cost out of energy charges. Is
you could do that, there's still room there. You could do that before those costs exceed, what we're showing in our class cost of service.
Okay. I have no further questions. Thank you.
Okay. Any other recross? Okay. Redirect?
I do, yeah.
Oh, sir, go ahead.
Following up on some EV questions, background-wise, EVs can be charged slowly or quickly, right?
I love EVs. I don't have one yet, but I'm not an EV expert.
Okay, but you're aware that, you know, you can charge EVs like a slow charge, or you can plug it in, you know, through like a high wattage.
I've heard that.
Okay. Now, under MECG's proposal, if somebody wanted to, you know, charge that EV at a faster rate, would it be more expensive or less expensive to do that under MECG's proposal?
What was their proposal? It's not really my, you know, testimony, and I can speculate on it if that's what you're asking.
Yeah, no, yeah. So by increasing the demand charge and lowering the energy charge, would that make it more expensive or less expensive to charge that EV using a high-speed charger, like a quick charger?
You're asking for analysis that requires assumptions on when they're charging, how long they're charging, and short of having that data, I really don't have an opinion or can't really answer that.
Yeah, that actually, the time of use is actually interesting. So under MECG's and MIEC's proposal, where, you know, you increase the demand charge, lower the energy charge, would the charge for charging an EV change depending on, you know, whether you're charging at any given point in the day?
Again, they're talking about 3 and 4 amp customers, and you're asking about EV charging. So you know, now we're assuming that it's an EV charging in a business. I don't know. So again, without more, you know, data to provide me to help you come to an answer, I really don't know.
Were you Amron's witness in the EV charging docket?
No. Do I look like him? I've been told I look like a lot of different people.
No further questions.
Okay, then to redirect.
None, thank you.
All right, then you can step down. The next witness on the list is Mr. Brubaker. Left hand. Please raise your right hand. Solemnly swear or affirm the testimony about to give in this matter is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
Good afternoon.
Good afternoon.
Could you state your name and business address for the record?
Sure, it's Morris Brubaker, Brubaker, 16690 Swingley Ridge Road, Chesterfield, Missouri, 63017.
And on whose behalf are you testifying and in what capacity?
The MIEC, it's a witness.
And did you cause to be filed in this case direct rebuttal and rebuttal testimony?
I did.
Okay, and do you have any changes or corrections to that testimony?
I do not.
If I were to ask you the questions that are in that testimony today, would your answers be the same?
Yes, they would.
Then I would request that Mr. Brubaker's testimony be admitted into the record, and I will consider him for cross.
All right. His direct is 500, his rebuttal is 501, and his surrebuttal is 502. They've been offered. Any objections that they're received? Hearing none, they will be received. And for cross-examination, we begin with public counsel.
I have no questions. Thank you.
Consumer counsel,
No questions.
MECG.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
There was some comments that I made earlier in my opening statement, referring back to a commission order in which the commission said that the peak and average approach double counts class energy. Do you recall that?
I do.
And were you a witness in that 2010 case?
I was.
Okay. I'm going to hand you, I might as well mark it as an illustrative exhibit, Your Honor, 752.
No, it'd be 754.
Oh, yes. You have exhibit 752 in front of you, sir.
I do.
And again, this is just an illustrative exhibit. I'm not going to offer it as evidence. Do you recognize this document, first off?
It looks familiar.
Okay. Would you be surprised if I told you it came out of your testimony in that 2010 rate case?
I would not be surprised.
Okay. Can you tell me, based upon this illustrative exhibit, how the average and excess approach is calculated?
Average and excess or average and peak?
Let's start with the average and excess, and then we'll compare it to the peak and average.
So the average demand looks like it's the green dashed line. That would be the first component of the average and excess demand allocation. Each class's average demand.
I'm sorry, could you speak up a little bit?
Oh, each class's average demand. Did you get all that?
Okay.
Okay. Then to that would be added a second component, which would allocate the difference for each class between the class's average demand and the class's peak demand to arrive at an allocation here of the difference on a system basis between system average demand and system peak demand.
Okay, so for the average excess methodology, the class average demand of 60 is multiplied by system load factor. Is that correct?
Yes.
Okay, and then the excess component, in this case 40, is multiplied times 1 minus the system load factor. Is that correct?
Right, and then allocated to classes based on the extent to which their peak demand exceeds their average demand.
Okay, can you tell me then how the peak and average is calculated?
The peak and average would be just the sum, basically, of the peak demands of each class and their average demand.
Okay, so under the peak and average, the class average of 60 is multiplied again by the system load factor. Is that correct?
Yes.
And then the excess is the full 100 multiplied by 1 minus the system load factor. Is that correct?
That's correct.
Okay, so the class average demand is calculated twice, one in the first portion and then again in the second portion of the equation.
Right, the average demand is a component of the peak demand, so it gets in there twice.
Okay, so you would agree then, when the commission found that peak and average double counts class energy usage, you would agree with that statement?
I would, and that's a number of commissions have come to that conclusion when looking at the peak and average allocation method.
Okay. Moving on, are you familiar with staff's class cost of service methodology for production costs?
I don't believe that I understand that the staff has a single cost allocation methodology for that.
Fair enough. You're familiar with their testimony in this case?
I am.
Okay. And their testimony would allocate fossil and nuclear units one way but then would allocate all renewable investment according to the energy allocator. Is that correct?
Correct.
Okay. Can you tell me, given your 50 years of experience in 40 states, is the energy allocator a NARUC recognized methodology for the allocation of fixed production costs?
No, it is not.
Okay. Do you believe that renewable assets, renewable generation, provide a contribution to the utility meeting its system peak?
Yes, all the forms of renewable generation that I'm familiar with, including solar, wind, hydro, be it run-of-river or pondage or Comstock, which is a mountain reservoir on the top and on the bottom that allows the water to flow from the top to the bottom through turbines to generate electricity. All those and and as well as biomass all have a demand component because they contribute to the meeting of system demand.
Okay. Are you familiar with the Mid-Continent Independent System Operator, MISO?
Yes. Or words to that effect, I always have trouble remembering that.
Okay, I have to. I was like, Mid-Continent or Mid-American?
Mid-Continent, I think is how it is.
Okay, anyway, is it your understanding that MISO, to some degree, assures that each utility meets certain resource adequacy requirements?
MISO specifies a requirement, and it's up to the utility to actually make that happen.
Okay, and under the MISO resource adequacy guidelines, are renewable generation assets provided a capacity value?
They are, yes.
Okay, so MISO recognizes that there is a capacity component with renewable energy, is that
correct?
Okay. Are you generally familiar with the Public Service Commission's IRP rule?
Yes.
Okay. And is it fair to say that the Missouri Commission's IRP rule basically, in very general terms, provides for a 20-year load forecast, looks at the current generation assets, determines if there's any shortfall between the load forecast and current capacity, and then seeks to meet that difference with future supply side additions or demand side management?
Generally, yeah, that's part of the analysis and part of the reason for having the IRP process.
Okay. Can you tell me, under the Commission's IRP rule, whether the Commission provides for a capacity value for renewable energy?
Yes, I think that would be accurate.
Okay, so the Commission's IRP implicitly finds that there's capacity value for renewable energy and that renewable resources are not there solely for energy generation.
I think that's the way it's looked at, although I don't think that the commission itself specifies what that attribution of capacity value is. I think that's really driven by MISO, but the commission is part of MISO, and so that when the commission looks at adequacy, it looks at it through the lens of the MISO requirements.
But the Commission's IRP rule specifically states to look at the capacity for, quote, all, end quote, generating resources.
Yes, I believe that's correct.
Okay. Final questions. Were you here for the opening statements in this case?
I was.
And did you hear staff's opening statement?
I did.
Okay. Mr. Keeble made some comments about there's no harm with the subsidies because all classes except for company-owned lighting are recovering their cost, even though they're not recovering their return on equity. Do you recall those statements?
I recall that, yes.
Okay. Do you believe that return on equity is a cost to the utility?
Yeah, I was a little confused by his statement. Certainly, return on equity along with the associated income taxes is part of, and debt is part of the overall return requirement. So say that your rate of return is below average doesn't mean that you're covering your costs.
Okay.
It means the opposite, you're not.
And so if you're not recovering that return and income tax cost, some other rate or customer class is covering that cost. Is that correct?
At the end of the day, if the utilities rates are set to meet its revenue requirement, that would be true.
Okay. No further questions. Thank you, sir.
All right, for legal services,
No questions.
for staff.
Just to be careful, I know exhibit 754 is not in the record, but, in this case, exhibit 754, has the word staff approach at the top. That is not accurate for this case, correct?
Yeah, I think that was accurate for the case in which this exhibit was actually presented. Right.
Okay. Yeah, that's the only question.
Although I would say that one of staff's allocation methods is average and peak, right? And so it's got the same problems that we talked about in connection with this illustrative exhibit.
Okay. Anything else from staff?
No.
All right. Then for Ameren, Missouri.
No questions, thank you.
All right. Come up for questions from the bench. Any commissioner questions for Mr. Brubaker? Okay. I don't have any questions either, so there's no need for recross. Any redirect?
I don't have any redirect.
All right. Then, Mr. Brubaker, you can step down.
Thank you, Judge.
Let's go ahead and take a break. It's 1:55 now. We'll take a 10-minute break, come back at 2:05. All right, it's clicked over to 2:05, so let's go ahead and get started again. The next witness is Robin Kleethermes. And Ms. Kleethermes, you're still under oath from earlier. You may inquire.
Thank you, Ms. Kleethermes. You're the same Robin Kleethermes that testified to Exhibits 204, 205, 214, and 230 earlier, correct?
Yes.
No further questions.
Okay. For cross-examination, begin with legal services.
No questions, Your Honor.
MECG?
No questions.
MIEC? Ms. Fleischer is not in the room. Consumer Counsel?
Thank you. Ms. Kleethermes, were you involved in the previous Ameren rate case, which was the rate decrease case?
Yes, in ER-2019-0335, yes.
And do you recall how that case was resolved with regard to class allocation, revenue allocation, among classes?
I do not.
Okay. Never mind.
Yeah, we have one more try. There, you better look it up.
All right, Public Counsel?
Okay, so, what's the basic difference between, I guess, questions that are appropriate for you, and questions that would be appropriate for Sarah? Is there, kind of a delineation there?
You can try, and
Okay.
then
Okay.
I'll tell you if they're more
Okay.
appropriate for Sarah or not.
Well, just, in general terms, what are the primary differences between the staff's cost of service study, Ameren's class cost of service study, and why is staff study better?
So I do think that would be a good question for staff witness, Ms. Laney. I will say from my understanding, the primary differences are the allocation of renewables and the allocation of distribution plans.
Is rate shock an issue the commission should consider when it decides how to allocate costs?
So rate shock is one of the things that we list. There's a list of consideration. Rate shock is one of them.
And do you think it's important for the commission to consider public feedback, when it considers things, policy issues like, or policy concerns like rate shock?
So I think so rate shock is something, and policy regarding rate shock is something that the commission should consider for all customers.
I'm saying would public comments that have been submitted to the commission from the public about this case be somewhere the commission could look to see, concerns that the public has expressed about things like rate shock?
Yeah, I think all public comments are.
And have you ever looked at public comments submitted, with the commissions to the electronic filing, information system, otherwise known as EFIS?
So I've looked at public comments for an array of cases. So for this case specifically, I have looked at a few public comments. I can't say exactly which public comments, but, I mean, we look at public comments for all the cases, so, yeah.
I'd like to have an exhibit marked. I've put it on my exhibit list as exhibit number 400, public comment.
Okay.
Label it confidential just because it has, customer-specific information in it.
All right.
So, kind of approach.
You may.
Okay, and if you could take a moment and look through that.
So it looks like it is a copy of public comment filed in a case.
Okay. And does this document, if you look at the very back, does this document appear to have been certified by the commission?
Yes.
And what was the date and is there a name that certified that?
It was, November 9th, 2021, and it was Judge Woodruff.
Actually, it'd be Secretary Woodruff for that context.
Sorry. Sorry.
That's all right.
So I guess at this point, I'd like to offer this exhibit as evidence.
All right, Exhibit 400's been offered. Any objections to its receipt?
Yes, this is the company, we would object with the lack of foundation and hearsay.
Response?
Yeah, well, there's been foundation. Ms. Cleathorn looked at these comments, as appears to be the comments that the commission has filed. This has been certified by the commission as is required. The commission can take it, it's not hearsay, the commission can consider these as statements of the public, not necessarily as the truth of the matters asserted. So I think this, and from a practical aspect, the commission has requested the public to comment on this case. And so what is the purpose of requesting public comment if the commission is not even going to consider anything that the public has taken their time to write the commission to explain the concerns they have?
Ms. Kaufman?
Yes, I'd like to, on behalf of my client, support the entry of these comments into the record. I think there is some question as to exactly what its legal status is. If in the public hearing, witnesses who testify are sworn in, that's usually, that's considered evidence in this record. And often, it's customary for individuals to bring letters and comments that are also entered into the record at these public hearings. And I think that most members of the public who receive the information that they can place these comments on the commission's website believe that this is, part of some record, and that at least the commissioners can consider it in the decision of this case. And so I think it would be appropriate to include it as, as with other comments indicate. The commission is sophisticated enough to consider this, whether it's some concern about hearsay or other comments that it's, I don't think that any other technical evidentiary concerns should be a barrier to entering this into the record, because it is something that the commission can understand, its origin, and understand generally that these are actual comments from the public.
Your Honor, I'll weigh in too then. These are hearsay, out-of-court statements offered for the truth of the matter asserted. So if Mr. Poston is offering them for the fact that there were public comments offered, I'll stipulate that there were, but he's offering them, I think, for the contents of those statements, which are much different. That is hearsay. So if he wants to offer them to show that the public has made comments, no problem. If he wants to offer them so that he can then in his brief say, John Doe said X, Y, and Z, then it's hearsay.
If I can respond.
Please do.
I want to refer to 386.410. It says, and in all investigations, inquiries, or hearings, the commission or commissioner shall not be bound by the technical rules of evidence. So I think the commission is well within its right to take these in and to consider them however they want to consider them.
Do you wish to respond?
Yes, I would, thank you. It does lack foundation in that it's not been established that Ms. Cleese-Thermos actually relied upon any of these comments. Didn't recall even reviewing them in full. And similarly, it is being used, and it's a fundamental evidentiary principle that hearsay not be allowed. So these are, as MECG's counsel explained, being used to prove the truth of the contents of them, and should be not admitted.
All right, I'm going to overrule the objection. The documents will be received into evidence. And did you have any further cross-examination?
I do not, thank you.
All right. Then for Hammer.
I have no questions for this witness, thank you.
All right, thank you. Come up for questions from the bench then. And, or the commissioners have any questions for Ms. Cleathermos? All right, hearing none. Then there's no need for recross, any redirect.
No, Your Honor.
All right, then Ms. Cleathermos, you can step down. And the next witness is Sarah Lange. And Ms. Lange, you are also still under oath. And you may inquire.
Good afternoon, Ms. Lange. Are you the same Sarah Lange that testified as to exhibits 205, 215, 221, and 231 earlier today?
Yes.
No further questions.
Okay. And for cross-examination, we begin with legal services.
No questions, Your Honor.
Okay, MECG? No questions. MIEC?
Yes, I have a few questions. Good afternoon, Ms. Lonnie, how are you?
Good, thanks yourself.
Fine.
You can't have
Fine. I just wanted to have, I have a document I would like to show Ms. Lonnie, and I guess it's a hearing exhibit.
Okay.
For MIEC.
Your next number is 508.
I'm gonna hand you the document. I wonder if you recognize that document.
If you are representing that you have printed this out of EPUS, then yes, I do recognize this document. However, I haven't done a side-by-side comparison to ensure it's accurately reproduced.
Well, subject to check, would you accept that it is, a response to an MIEC data request?
Yes.
Could you go ahead and read, the question and the answer, or summarize the questions, or if you'd like me to, I will. I'm more interested in your answer being on the record, but, you know, I'm happy to summarize the questions, or you can read the questions.
I think the questions asked who contributed to the report, in which section, and please indicate the relevant college coursework that witness has taken. I indicated that with the exception of the sections authored by staff witness Brooke Mastriani, I generally prepared the staff CCOS report and listed the coursework that I've taken related to power system economics, energy markets and structures, energy economics and finance.
I'm sorry to interrupt, but could you just go ahead and read your response into the record?
I suppose I could take the course time to do that. 828.1-1.A, Sarah Lange. 828.1-1.B, Sarah Lange. 828.1-2.A, Sarah Lange has not taken courses specifically entitled Electrical Engineering and is without knowledge as to the extent that her coursework overlapped with those required for electrical engineering. Coursework includes 2014 spring, quotation, ETST 276, power system economics, comma, close quote, fall 2014, open quote, ENRG 420, energy markets and structures, comma, close quote, and spring 2015, open quote, ENRG 412, energy economics and finance, comma, close quote, completed at Bismarck State College, and open quote, TG 126 space 70 COMP space AIDED space drafting, comma, close quote, and open quote, TG 100-01 intro to drafting, comma, close quote, completed at Southeast Missouri State University, comma, approximately 2002 to 2004. 828.1-2.b, Sarah Lange has not conducted an, open quote, in-depth analysis of the design and operation of the distribution system, comma, close quote, of Ameren, Missouri, nor any other electric utility. Sarah Lange has conducted similar reviews of the investment records of the Empire District Electric Company as part of its last general rate case, period. Sarah Lange has not conducted an analysis of the expense records of Ameren, Missouri, nor any other electric utility, period. 828.1-3. These provisions are generally similar, comma, except that LPS requires a minimum demand of 5,000 kW at primary voltage, and Rider I, as currently promulgated, requires a minimum demand of 100 kW at secondary voltage. To the extent that the Commission orders implementation of staff's recommendation that Ameren, Missouri require, comma, on a non-optional basis, comma, that non-residential customers participate in Rider I, comma, which incorporates a time of use element to customers' billing as those customers obtain AMI metering equipment, comma, the more specific requirement of the LPS schedule concerning minimum demands would govern, comma, and clarifying language would be implemented as part of compliance tariffs. DR response provided by Sarah Lange, and then it provides my email address.
I'd like to have that exhibit admitted into the record.
All right, it's been marked as 508, and it's been offered.
Your Honor, can we limit Exhibit 508 to the second and third page? The first page is really irrelevant. It's just.
What is, I've not seen a copy of it yet. What is
The first page is just a objection.
Oh, okay.
To the extent that it's calling for attorney-client privilege or work product privilege.
Ms. Plushy, do you agree with that?
I don't have a problem with taking the cover letter off.
Okay, cover letter is gone. With that modification, is there any objection to 508? All right, hearing no objection, 508 will be received.
That's all I have.
Okay. And Consumers Council.
Good afternoon.
Good afternoon.
Do you recall the resolution of the previous Ameren rate case, electric rate case?
I took the second half of my manager's cross-examination to attempt to look that up. I got as far as determining that that was calculated in Appendix J, or Exhibit J to the non-unanimous stipulation and agreement, which was, I believe, approved by the Commission in case number ER-2019-0335. I did not get far enough to completing the math, but the numbers that I can see on that page, coupled with my general recollection of the case, is that we followed a multi-step process in that case, and that under that multi-step process, the normalized revenue with the tax reduction applied was the starting point for cost allocation. So if you go back to the prior non-tax rate case, you had whatever the class revenue requirements were in that case. Those were then modified on a non-equal percentage basis by the tax case, with more favorable treatment, broadly speaking, being given to the LPS, LGS, and SPS classes, less favorable treatment, broadly speaking, being given to the res and STS classes. And so that was then the starting point for the last rate case. So there's some difficulty in your question in saying whether that change is part of the last rate case or the prior implementation of the tax reduction case. Then from there, it appears that a series of steps were followed that results in other than an equal percentage increase. But the details of that, I'm struggling to recall exactly who was treated most favorably and who was treated least favorably.
Thank you for that very thorough answer. But suffice it to say that the largest customer classes were treated more favorably in the way that the revenue change was applied to the previous, the Ameren rate case just previous to this one.
Again, the question is whether you view that tax case as being a full implementation. But if you go back to from general rate case to general rate case, I would agree with your statement.
Thank you.
All right, public counsel.
Thank you. I'm going to ask you the question that I asked this week. So, in general terms, what are the primary differences between staff's class cost of service study and Ameren's class cost of service study? And why is the staff study more reliable for the commission?
I guess I would preface by saying that even under the Ameren study, you get the same results essentially as staff study, so I wouldn't really focus on which between those two is more reliable because they draw the same conclusion in general. That said, we attempted to account at least to some level of customer-specific infrastructure that is ignored in the Ameren study. And we attempted to just apply some basic logic to the consistency of the treatment of generation plant and the revenues that are received from the market value of that energy that is generated. And where that really comes most to light is wind. Under the wind generation, it's effectively all capacity cost. So if you effectively allocate the entire cost of the wind using a capacity allocator, such as the A&E or any other capacity allocator, and you don't really have any energy cost to assign, like you would typically have fuel or gas or coal or nuclear fuel with any other type of generating plant, you really are just allocating capacity. And if you're just allocating capacity as capacity, but then you allocate revenues on energy, you end up with a just patently unreasonable mismatch. And so that's what I've sought to avoid. There's a number of ways you could seek to avoid it. Under the time that was available in this case and under the methods available in this case, I think that my approach of generally looking at the renewables on a KWH basis is the more reasonable approach than the company approach.
Okay. A similar question, but in regards to the modifications that the industrials have proposed. Why are those? Well, one, do you agree with any of the modifications they made? If you don't agree, why?
No, I mean, they're not really big enough to have any different opinion on than the company approach. I mean, they're just not significant.
Okay. So what is the RAP manual?
The RAP manual is a document put out by the Regulatory Assistance Project. There's been a series of documents put out by the Regulatory Assistance Project. Several deal with rate design, several deal with cost allocation. The RAP manual came out, I believe, in 2019. I think I appended it to my rebuttal testimony. I would defer rather to the date on that. But effectively, it's an attempt to look at various approaches one could take in allocating costs that begin to acknowledge the changes we've seen in the electric industry, particularly in the last 10 years, but really over the last 20 to 30 years. The advent of retail wheeling in the 90s was just kind of a possibility when the 92 NARUC manual came out. And I mean, now we have our utilities, especially Ameren, participating in full-blown energy markets. It's just a different world, and RAP attempts to summarize a lot of the RAP manual is really summarizing regulatory decisions that have been reached around the country, and summarizing them in a way that is more accessible to the average analyst who doesn't have time to read every decision in every case.
So you talk about it looking at, changes and things in the last 20 or 30 years. Is the methodology that, Ameren has used, is it an older methodology that was developed, I guess before 1992? I would assume.
Well, when you say methodology, there's a couple of different areas where I criticize Ameren's approach. One of those is an allocation of production costs. One of those is in classification of distribution costs. The production cost allocation Ameren used definitely predates the RAP. It predates NARUC. It goes back to when you didn't have, frankly, electric calculators. So yeah, it predates RAP on the production side.
Mr. Brubaker's testimony criticizes the RAP manual for being, quote, heavily influenced by consideration of greenhouse gas reduction mandates, end quote. Do you rely on the RAP manual, because of the environmental benefits of the approaches that they propose?
I was legitimately confused by Mr. Brubaker's testimony on this point, because my reliance on the RAP manual primarily related to distribution side of things. And no, the cost that you allocate on a customer basis to a class is not in any way, shape, or form influenced by greenhouse gas emissions. So I didn't catch that.
Okay. So, I mean, your approach seems to rely more on energy use than their approach, right? I mean, as far as how you allocate costs.
Well, it's not just the allocation of costs, it's the allocation of revenues, and I would say their approach ignores the energy approach in that it does not attempt to levelize capacity costs across energy, and it doesn't attempt to convert the revenues generated by capacity to the offset of the cost of the classes that are paying for those revenues, or I'm sorry, for that capacity.
Okay. Did staff have problems with the data that Ameren provided in conducting your study?
So on the distribution side, yes, we had significant difficulties in obtaining the data that I believe was appropriate to check Ameren's distribution classification and related allocators, and we had therefore difficulty in formulating our own distribution classification and attendant allocators. However, in large part, those data concerns have been addressed through the non-unanimous stipulation and agreement, so I'm not sure how much detail I can get into that here today.
Okay. So that didn't as much impact your class cost study, or?
Okay, there may be some confusion here. So the class cost study looks at all of the costs, and it looks at all of the revenues. Ameren and staff did very different, well, didn't do very different things. Ameren and staff did different things on distribution costs and expenses. The industrials, I believe, adopted that position whole cloth on distribution. Ameren and staff did somewhat different things on some of the areas of production costs. And again, the industrials deviated somewhat from Ameren on some of those production cost allocations. But most of the costs and most of the revenues for most of the studies are allocated very similarly, if not, essentially using the same allocator on different amounts. The differences draw more from the interpretation of those results and the failure of certain parties to adjust those results for the actual revenue requirement recommendations they provided.
Thank you. That's all I have.
Ameren, Missouri.
No questions, thank you.
All right. For questions from the bench. Do we have any questions for Ms. Lange? All right, I do have some questions. Both questions are about issue I, which is about the Rider B credits and their possible suspension. First of all, can you explain to me what staff's proposal is, assuming there's no suspension or anything? How are the Rider B customer credits going to be? Are they going to be increased in proportion to the percentage of increase in the revenue requirement? Is that staff's position also?
That's where it gets tough, and that's where it matters what happens on revenue allocation and rate design.
Okay.
So right now, there's, and this is a tariff, so we can correct it in the briefs if we need to, if I'm wrong here, but my recollection is that for the LPS and SPS class, the Rider B credit level is set at the same amount within the tariff without regard to which of those two rate schedules customers served under. So if, for example, the LGS, SPS, revenue requirement changes disproportionately or in a different direction or by a dissimilar amount as the LPS schedule, then it may not be appropriate to adjust those evenly. Under the staff's proposal, everything moves the same. It's not a concern. You just find the percent and apply it to everything.
Okay, I think I understand that. Just to be clear, your proposal to suspend the Rider B credits would only take effect if the commission were to order something other than an across-the-board increase. Is that correct?
Yes, and we made that recommendation hoping it wouldn't come to this. You know, we just need to know what the amount is in order to make sure that the credit equates to that amount. And without cost data, we can't say what amount to adjust it by. So we're hopeful that there'll be productive back and forth moving forward, that this will not be an issue in future cases.
Okay. And then as to J3, which was the late adopted position, why do you believe that a further study of Rider B issues is needed?
For the exact reason you just said. I've got the DR response included in my testimony somewhere, but we asked Ameren just as a check, hey, give us your Rider B work papers, and they said, well, adjust it by the same amount as the class. And we said, no, really, what is the cost for this substation that you would need to impute? And again, I can't get into a lot of details because of the stipulation we've agreed to, but we just need to know what the approximate cost of one of these substations is so that we can know if the credit is somewhere close to that cost or not, if it's too much, if it's too little, and if it's being assessed on the proper determinant.
So would this study be necessary if the commission were to approve an across-the-board increase rather than something else?
Yes, so the study is forward-looking. The study is when we get to this next rate case, how do we avoid everything that's happened in this case, and the deterioration in communication that occurred in this case.
Okay, so the study is your proposal, no matter how the commission decides rate design, is that right?
Yes.
Okay. Okay, I believe that's all the questions I have. Any recross based on those questions from the bench?
Yes, Your Honor.
Mr. Woodsmall.
Now I'm very confused. You have the staff's class cost of service report in front of you?
I do.
Page 54. There, please.
I'm there.
Okay. Line 9, you state, well, line 8, that discounts provided to primary customers under Rider B be suspended. Are you now recommending still that they be suspended, or that the commission simply tell you how much of any revenue increase be applied to Rider B?
I think if you look at our position statement, and I think there it cites in testimony where I made this clarification, what we're after, or where we are as a recommendation at this point, through subsequent rounds of testimony, is if you're not making shifts of of revenue responsibility away from the classes that are served at primary. We can let the existing proportion of Rider B credits float for now because it falls within the, range of our study results where we did attempt to make an inferred level of Rider B or of customer-specific substation investment. However, if your proposal is accepted, or MIEC's proposal, where those primary service classes are getting a less than system average increase, then that moves it off of staff study. And if it's moved off of staff study, then we know that the company didn't make allowance for these imputed costs, and so then we cannot recommend that those credits increase proportionately.
Okay, so if the parties agree that any revenue change for the primary classes not be applied to Rider B, that it only be applied to base rates, if you will, then this issue of them being suspended isn't an issue. That we just leave them at current levels.
So that's not what I just said, but for these purposes, if we get a robust study going forward and we fix this going forward, I think that might be a reasonable resolution. We're sympathetic to these customers. We think there should be some rate difference, but right now, I think for customers who are not receiving Rider B credits, they're not getting treated fairly.
Okay, so now I'm further confused. Under the non-unanimous stipulation, there is some, or the second stipulation, not the non-unanimous, or the unanimous one, I'm sorry, the smaller second one. There is some record-keeping requirements that would affect how Rider B is calculated going forward.
There is not in what was filed.
It wasn't included in that second stipulation.
It was not.
It's not in any of the stipulations.
It is not.
Why was that issue, I thought, taken out of the issue list, the record-keeping stuff?
I believe that is the issue that was reinserted into the issues list when I logged in at, the next morning following the filings.
Okay, so it was in the issue list, fell off the issue list, then staff inserted it back into the issue list.
And Ameren, as well as staff, provided position statements on that issue.
Okay, so as of right now, it is your opinion that there is no agreement as to what information will be provided going forward in order to allow you to do, I think you said, robust study.
At this point, I have not reviewed the amended Ameren position statement. It has been relayed to me that Ameren did not agree to the study and provided a position statement rebutting the need for the study and stated they will not do the study, but I defer to Ameren's position statement for that. So in light of that, I think that's correct. I think Ameren could have come back and said, we agree to the study, but
Okay,
I just haven't seen it yet.
So bottom line, in order for me to educate my clients, is it staff's position that these clients that have these customers that have installed their own substation, staff wants to take that credit away from them?
No, because staff's recommendation does not require that under staff's recommendation. If you get your rate shift recommendation, and for the clarity of the record, you being MECG, then because that would reduce class revenues below the level that is assumed in the staff study, then we would either need to suspend those credits, or frankly, I do like your suggestion you threw out, and I don't have management approval to say this, but I'll say it anyway, just to lock them in at the current level of discount and not grow that discount proportionate with the demand charge increase, which would otherwise be the way they're grown.
So just speaking for yourself, there is a resolution of this issue short of suspending the credits.
Sure,
Okay.
Order staff shifts.
Okay. No further questions, thank you.
Okay. Any other recross?
I have a question.
All right, go back to MIEC.
Ms. Lange, isn't it true that in order to obtain Rider B credits, the customer has to pay for and bear the cost of the investment in that substation?
That's not the issue.
It's a yes or no question. I mean,
Well, what that substation is makes it not able to be a yes or no question.
okay, let me ask the question again. Is it true that in order to obtain Rider B credit, the customer has to pay for the substation and bear the cost of investment in the substation? Is that correct?
I don't know what the substation is.
The substation that the Rider B credits are meant to compensate for in the tariff. The substation that the credits are being received for, the customer has to pay for it and invest in it and pay for the investment in it. Is that correct?
The Rider B credit is to refund to the customer the cost of a company substation that the customer isn't using.
I know other questions.
Okay, was there any further,
Some additional costs and to
right,
clarify.
was anybody else before Cameron? Right, then for Cameron,
Sorry.
that's all right.
So I just want to clarify, you're saying that Rider B credits are not to credit back to the customer who invested in their own dedicated substation?
I am not aware of anything that would tie the cost of a Rider B credit to the cost of what a customer chooses to invest in. If a customer chose to, build an indoor substation when an outdoor substation would have done, Rider B doesn't adjust for that. If a customer chooses to buy the latest and greatest transformers out of, Sweden, or whatever Scandinavian country it is we get all our transformers from nowadays, the Rider B doesn't adjust for that. My understanding is that Rider B is intended to compensate the customer who is being charged a, LPS or SPS bill for the value that the company did not have to include in revenue requirements for a substation that the company did not have to build.
Okay, thank you.
Okay, any redirect?
Yes, Your Honor. Ms. Lange, are you familiar with the 1992 NARUC manual?
I am.
You were asked about that earlier. Does that 1992 NARUC manual discuss average and peak methods?
It does.
Earlier, you also included a statement about the how the recommended revenue requirements serve as a basis for some of these class cost of service study recommendations from like MECG and MIEC.
Yes.
Can you explain how those different assumptions change the outcomes?
That's kind of the crux of this issue, and one of the best illustrations of it is the exchange that Mr. Woodsmall had earlier with Mr. Hickman, where he asked him to do some simple arithmetic of subtracting percent of requested increase and the percent of increase that's contemplated in the stipulation. And that's just fundamentally inappropriate approach to how you look at the issue, because that assumes that change in revenue requirement increase is allocated evenly among all the classes, and we simply know that's not true. We know that the allocated cost of service for the SGS and residential classes is significantly higher than the allocated cost of service for the LPS and SPS and LGS classes. And so to take the same amount out of each of those figures is just illogical. That's really where you come up with this mismatch where, you know, on the one hand, you have industrial interests who are saying you should have a reduced ROE, or you should have a reduced rate base in renewables, or you should have a lower average energy cost, but then they allocate the company's full cost of service. And you can't just smoothly take those percentages away from each other because they're not allocated smoothly. You have to go back through line by line, and that's why it's important to do an independent study that ties to that party's revenue requirement to have any credibility in the class cost of service arena.
And then finally, when we're talking about who pays for wind and who receives the benefit of wind, can you expand on that a little bit, what MECG's proposal would actually result in?
The failure to acknowledge the unique, cost and revenue arrangement of generation that does not have significant variable energy costs undermines the credibility of any study. You could still use it for general purposes of saying, are you in the ballpark, that kind of thing. You just need to be very aware that if you're allocating all of the cost of wind on capacity, as opposed to something like the levelized cost of energy, but you're allocating revenues generated by that facility on energy, that you've created a mismatch. And in this case, that mismatch is easy to quantify. It's 65% of the costs are going to SGS and RES, and only, I believe it's 55% of the revenues, but those numbers can easily be obtained from review of any of the witnesses' testimony in this class by a comparison of their energy allocation and a comparison of their capacity allocators. And except for staffs, because staffs, we did take that into account. We did look at the revenue requirement and the net revenue requirement with each generation type, so that we could look at if they needed to be allocated differently, and we could do what we did, which was look at a high case and a low case to determine if there was anything in this case that merited further study.
And then, is the allocation of renewables on kilowatt hour energy consistent with the recovery of renewables via the company's RESRAM, meaning the Renewable Energy Standards recovery mechanism?
It would result in a similar treatment, and it would also be consistent with the company's fuel adjustment clause and the treatment of net energy costs within the FAC.
No further questions.
All right, then, Ms. Cluther, Ms. Lange, you can step down. I almost called you Cluther with you.
Old habits die hard.
That's right. All right, the next witness then is Mr. Chris, and I believe he's on the line. Mr. Chris, are you there? Let me see. He was here a minute ago. He's shown as being on the WebEx screen here, so he may have just stepped away for a moment.
Well, they're waiting on you. Steve, are you on?
Mr. Chris, are you there yet?
I am here. Can you guys hear me?
Loud and clear.
Awesome.
We're ready for you to take the stand here. If you please raise your right hand, I'll swear you in. Do you solemnly swear or affirm the testimony about giving this matter the truth, the whole truth, nothing but the truth?
Yes.
All right. You may inquire.
Thank you, Your Honor. Would you state your name and business address for the record, please?
My name is Steve W. Chris. Last name is spelled C-H-R-I-S-S. Business address is 2608 Southeast J Street, Bentonville, Arkansas, 72716-0550.
And do you have in front of you your direct and your surrebuttal testimony?
Yes.
Can you hear me okay, just in case?
I can. Yep, you're good.
And I'll tell you that your direct has been marked as exhibit number 750 and your surrebuttal has been marked as exhibit number 751. Do you have any changes to exhibit 750, your direct testimony?
No.
Do you have any changes to your surrebuttal testimony, exhibit 751?
No.
If I were to ask you the questions contained in exhibit 750 and 751, would your answers be the same here today?
Yes.
With that, I'd move for the admission of exhibit 750 and exhibit 751 and tender the witness for cross-examination.
All right, 750 and 751 have been offered. Any objections to their receipt? Hearing none, they will be received. For cross-examination, we begin with MIEC.
No question, thank you.
For Ameren,
Just briefly, please. Mr. Chris, you would agree that the charging of electric vehicle fleet would generally put upward pressure on a non-residential customer's demand, right?
So timing matters. To the extent that charging is done at a time other than when the customer is otherwise peaking, it can be managed. If you are charging coincident with the otherwise applicable peak of that customer, then it could, yes.
So your proposal to increase the LGS and SPS customers' summer and winter demand charges by 3 times the % class increase potentially then could have a chilling effect on EV fleet adoption. Would you agree?
No. Ameren's demand charges are really low. Within the context of where the industry is for demand charge levels, it would probably take quite a bit more to do that. Also, I don't necessarily think that adjusting charges for a single purpose is good public policy, because ultimately you're turning the SPS and LGS rate into a single purpose rate if you're making specific adjustments because of one particular usage. So, within the context of this, I'm not sure that that's the way to go. Other states have taken a look at this and have, created targeted demand limiters and other provisions in their otherwise applicable rates that can help to incent demand charging or EV charging. And, that's fine. I mean, ultimately, at some point within the customer's journey on EV charging, you'd hope that they would get to a point where the charger usage is high enough that the load factor increases over and above where it would be just on its own. And I guess that's part of the other thing, is that the customer's load factor matters too. So if a customer is above a certain load factor on either of those schedules, the demand charge isn't going to be as impactful as it might be if they're a very low load factor customer. So there's a lot of factors that play into it. And, it's certainly just caution against making this discussion into a single use sort of discussion for customers on the rates.
Those are all my questions. Thank you.
okay. Then for legal services,
No questions.
Consumers Council.
Hello, Mr. Chris, this is John Kaufman. I have no questions for Mr. Chris. Thank you.
For Public Counsel.
No question.
For staff.
No questions, Your Honor.
All right, then we'll come up for questions from the bench. Any commissioner questions for Mr. Chris? All right. Well, I do have a question I'm going to try and ask, and it's about the allocation of the rate increase to the various customer classes. I believe you provided charts in your testimony that would show what would happen if the larger classes or the industrial classes had a 41% move towards actual cost of service. Is there a way to calculate what that percentages would be if, say, the commission said wanted to move to 20% closer, some smaller amount or larger amount? Is there a way to easily translate that numbers in your chart into using different percentages?
So that is a good question. I believe there is. It would basically just be the same model and would just target, a different outcome. So instead of the 41%, it would just be a matter of calculating it such that the reduction would be to the number chosen.
Is there anything? Is there the 41% that you chose? Is there anything magical about that number, or is that just a suggestion on on moving towards, the full adjustment?
So that, the 41% itself is more of an outcome. So the, you know, the recommendation talks about using 50% of the reduction for the revenue neutral shift and then using 50% to lower the impact for all classes. So what you would basically just do is instead of, so if you wanted to go down to 20 or 25%, something lower, instead of the 50% of reduction used for revenue neutral shift, you'd probably move it down to 25% of reduction used for the shift and then apply rest on an equal percentage. And so as you adjust that percentage up and down, that will change the impact. But as the amount used for the revenue neutral shift goes down, the reduction in subsidy will also go down, but then, you know, you'll have those top end increases will come down, the lower end increases will come up.
Okay. Well, thank you. That's helpful. And that's all the question I had for you, Mr. Chris. Was there any recross based on that question? Staff?
Yeah, Mr. Chris, on page 23 of your direct testimony, there's a table 5 at line 10.
I see it.
On the right column of table 5, it says rate of return index value. Can you tell me what that means?
So the rate of return index value is essentially the relationship of the rate of return for a particular class versus the total rate of return. So parity would be a 1.00. So if everything is set at cost for the revenue requirement for that class, it will be 1.00. If it's above cost, it'll be above 1. If it's below cost, it'll be below 1. And so essentially, if the number is above 1, that class is subsidizing other classes. If the number is below 1, that class is being subsidized.
And looking at the last row of table 5 where it says present case and the rate of return index value is 1.54, you see that?
I do.
1.54 is the lowest, it's the lowest rate of return index value on that chart, correct?
Correct.
So the rate of return index value in the present case is the lowest it's been since at least 2007, is that right?
That's correct, but still in a position of subsidizing other classes.
No further questions.
Okay, any redirect?
Yes, very briefly, working backwards, you had a question from the bench, referring to, I believe, table 7 on page 28 of your direct. Do you recall that, where it talks about a 41% reduction of the subsidy?
I do.
Now, just to make sure the record's clear, you said that 41%, so your methodology would take the difference between what was requested in this case, what is authorized, and apply half of that to eliminating the residential subsidy. Is that correct?
That's correct.
And so, by way of example, the company asked for a $300 million rate increase in this case. The stipulation provides for a $220 million rate increase. The difference is $80 million. It would take half of that, $40 million, and use that to address the residential subsidy. Is that the correct calculation?
Correct.
And so if the commission, so the 41%, as you said, is a fallout from applying half of the difference, correct?
That's correct.
Okay, so if the commission wanted to use something different, for instance, if the commission wanted to use 1/4 of the difference, then it would be $20 million of the $80 million difference would be applied to reducing the residential subsidy. Am I doing my math correctly?
That's correct.
And so the 41% would then be a fallout from that number.
Well, it would be a different number that would fall out from reducing that number, but yes.
Okay. And then you had a question from Ameren regarding the possibility that your proposed rate design for LGSSP may drive
an increased demand. Do you recall that question?
I do.
Okay, would you agree that demand for those classes are determined based upon a 15-minute interval?
Yes, that's my understanding.
And check the math if you want to, but there are 35,040 distinct 15-minute intervals during the year. Is that correct?
That's correct. I mean, ultimately, those 35,000 intervals are then broken into the 12 billing months, but essentially it's whatever the 15 minutes during the billing month is of peak demand.
So in order for your proposal to drive an increased demand, the usage, the electrification would have to occur at that specific 15-minute interval that the company is otherwise incurring its peak demand. Is that correct?
So it would have to occur coincident with when the customer is otherwise increasing its peak demand. So if, as an example, say in the month of June, we had a store that set its peak demand at 5 p.m. and that peak demand was a megawatt. If a charger was added and the charger operated during that same interval, then you would add the charger's demand on top of that. But if it's noon and the store is sitting at 600 kW and you add the charger's demand and that charger's demand is less than the 400 kW difference, it won't change the demand, the billing demand for the month. So it really is the extent to which that charger being on that meter increases the billing demand, and a lot of that will be dependent on what else is going on, behind that meter.
I understand. I was applying 8,660, 8,760 times 4 because I was accounting for a demand ratchet, but that only applies to facilities demand, blah, blah, blah. So I understand your response now. Thank you. I have no further questions.
Okay, then, Mr. Chris, you're finished for today.
I appreciate it. Thank you.
The next witness was Dr. Mark, and he's already testified and been cross-examined on these issues. Then Ms. Hutchinson for Consumers Council, and we indicated she would be excused. You want to go ahead and offer her testimony at this point?
Yes, I would offer into the record Exhibit 700 and 701, which are Jackie Hutchison's direct and surrebuttal prepared testimony in this case.
700 and 701 have been offered. Any objections to their receipt? Hearing none, they will be received. And that takes care of the evidence for today. We still need to take care of the testimony that is coming in by way of the stipulation and agreement issues. Those numbers have already been assigned numbers by the list that were presented by the parties. So I'll just go through them. Number 1 is Wood Direct. 2, C and P is Wood Surrebuttal. 3 is Muniz Surrebuttal. 4 is Lansford Direct. 5 is Lansford Rebuttal. 6 is Lansford Surrebuttal. 7 is Byrne Direct. 8 is Byrne Rebuttal. 9 is Byrne Surrebuttal. 10, C and P are Bowden Direct. 11 is Bowden Rebuttal. 12 is Bowden Surrebuttal. 13, C and P is Aurora Rebuttal. 14 is Aurora Surrebuttal. 15 is Reed Direct. 16 is Reed Surrebuttal. 17, 18, and 19 were Willis's testimony that's already in. 20 is Bulkey Direct. 21, C and P is Bulkey Rebuttal. 22 is Bulkley Surrebuttal. 23 is Sagel Direct. 24, C and P is Sagel Rebuttal. Ferrugi's was number 25, and that's in. Austin Frot's Rebuttal, 26 C and P. 27 is Spanos Direct. 28 is Spanos Rebuttal. 29 is Spanos Surrebuttal. And Hickman's are 30 and 31, they've been in. 32 is Selby Rebuttal. 33 is Peters Direct. 34 is Meyer Direct. 35 is Meyer rebuttal. 36 is Meyer Sur rebuttal. 37 is Moore direct. 38 is Moore rebuttal. 39 CNP is Burke rebuttal. 40 is Burke Sur rebuttal. 41 is Huss rebuttal. 42 is Nauert direct. 43 is Nauert Sur rebuttal. And 44 and 45 are the Harding's testimony, those are in. And then the other one for electric would be Faruqi's rebuttal, which is 73, and that's also in. So I'll get to the gas in a moment. Any objection to the electric ones? Hearing none, they're all.
In your honor, just to clarify the record, I might have misheard you, but I think you said 16 was Sir rebuttal and it's Reed rebuttal.
You are correct. You are correct. Glad to know somebody's listening to me. Anyway, those exhibits are going to be received into evidence. Then moving over to the Ameren gas one, 46 is Wood direct, 47 is Muniz rebuttal, 48 is Lansford direct, 49 is Lansford rebuttal, 50 is Lansford Sur rebuttal, 51 is Byrne direct, 52 is Byrne rebuttal, 53 is Byrne Sur rebuttal, 54 is Klein direct, 55 is Klein rebuttal, 56 is Klein Sur rebuttal, 57 is Bulkley direct, 58 C and P are Bulkley rebuttal, 59 is Bulkley Sur rebuttal, 60 is Sagel direct, 61 C and P are Sagel rebuttal, 62 is Hassenfratz rebuttal, both C and P, 63 is Spanos rebuttal, 64 is Spanos Sur rebuttal, 65 is Harding direct, 66 is Harding rebuttal, 67 is Eggers direct, 67, oh, that's both C and P. 68 is Eggers rebuttal. 69 is Berg direct. 70 is Selby rebuttal. 71 is Moore direct. And 72 is Moore rebuttal. I believe that's all for the gas. Any objections to those, receipt of those documents? Hearing none, they will be received. Moving on to staff. Again, first for the electric side. 200 is Ferguson direct. 201 C and P are the staff report for cost of service. 202 are staff accounting schedules. 203 is Ferguson's direct late filed affidavit. 204 and 205 are already in, that's Cleveland Thermos direct and the staff report on class cost of service. 206 is Boosted rebuttal. 207 C and P is Cassidy rebuttal. 208 C and P is Chari rebuttal. 209 is Coffer rebuttal, 210 is Cox rebuttal, 211 is Cunningham rebuttal, 212 CNP is Eubanks rebuttal, 213 is Ferguson rebuttal, 214 and 215 are already in, 216 is Sean Lange's rebuttal, 217 CNP is Lubert's rebuttal, 218 is Mastrigiana's rebuttal, 219 is Oldschlager's rebuttal, 220 is Stallman's rebuttal. 221 is an order granting a motion to late file schedule. 222 is Amethyst Sur rebuttal and True Up direct. 223 CNP is Bolin Sur rebuttal. 224 CNP is Caldwell Sur rebuttal, True Up direct. 225 CNP is Chari Sur rebuttal. 226 is Cox Sur rebuttal and True Up direct. 227 is Cunningham Sur rebuttal. 228 is CNP is Doherty Sur rebuttal, True Up direct. 229 CNP is Eubanks True Up and direct. 230 and 231 are already in. 232 CNP is Sean Lange's True Up direct. 233 CNP is Lubert Sur rebuttal. 234 CNP is Lyons Sur rebuttal and True Up direct. 235 is Major Sur rebuttal. 236 is Mastrigiana's Sur rebuttal, True Up direct. 237 CNP is Oldschlager's Sur rebuttal. 238 is Rawlings True Up direct. 239 CNP is Young Sur rebuttal and True Up direct. And 240 CNP are staff counting schedules. And we've got then 241 CNP is Ferguson Sur rebuttal, True Up direct. That's all for the electric. Any objections to their receipt? Hearing none, they will be received.
Your Honor, I don't have any objections. On 205, I'm not sure if you also noted that those are both, there's both a public and confidential version of 205 as well.
That is correct, and I believe I did overlook that. All right, then moving on to the gas for the staff. 242 is Ferguson direct. 243 CNP is staff report cost of service for gas. 244 is staff accounting schedules. 245 is late filed affidavit of Ferguson. 246 is postage direct. 247 is staff report class cost of service for gas. 248 is Buckledge rebuttal. 249 is Boosted rebuttal. 250 is Ferguson rebuttal. 251 is McNutt rebuttal. 252 is Olig-Schlager rebuttal. 253 CNP is Patterson rebuttal. 254 is Stallman rebuttal. 255 is Dr. Wan's rebuttal. 256 is Amanthorpe rebuttal, true up direct. 257 is Buckledge rebuttal. 258 CNP is Boland's rebuttal. 259 is Budig rebuttal. 260 is Caldwell true up direct. 261 CNP is Doherty rebuttal and true up direct. 262 CNP is Ferguson rebuttal true up direct. 263 is Major rebuttal. 264 is McNutt rebuttal. 265 CNP is Olig-Schlager rebuttal. 266 CNP is Young rebuttal true up direct. 267 CNP is Wan rebuttal true up direct. 268 CNP is staff accounting schedules for gas. And I believe that's it for gas for staff. Any objections to the receipt? Hearing none, they will be received. And moving over to public counsel, for electric first, 400 through 403 are already in. 404 is Riley rebuttal. 405 CNP is Murray direct. 406 is Murray rebuttal. 407 CNP is Murray Surrey rebuttal. 408 is Robinette rebuttal. 409 is Mantle direct. 410 is Mantle rebuttal. 411 is Mantle Surrey rebuttal. 412C is our public comments on gas.
That's, we just cross that out.
Okay. And, okay, so for any objections to the electric exhibits? Hearing none, they will be received. Moving on to gas then is Murray direct is 413 CNP. 414 is Murray rebuttal. 415 CNP is Murray Surrey rebuttal. 416 is Mantle direct. 417 is Mantle Surrey rebuttal. 418 is Robinette rebuttal. 419 is Robinette Surrey rebuttal. And 420 is Marks direct on gas. Any objections to the receipt of those documents? Hearing none, they will be received. Moving over to MIEC, which I believe are all electric. 500 through 502 is Brubaker's testimony, that's already in. 503 is Andrews direct. 504 is Andrews Surrey rebuttal. 505 is Meyer direct. 506 is Meyer rebuttal. 507 CNP is Meyer's Surrey rebuttal. Any objections to the receipt of those documents? Hearing none, they will be received. And then moving over to Consumers Council, that was Hutchison's direct and Surrey rebuttal, that's already in. MECG, Chris's testimony, which was 750 and 751 is in. So then 752 is Teague direct and 753 is Teague Surrey rebuttal. Any objections to their receipt? Hearing none, it will be received.
One question, Your Honor.
Sure.
Exhibit 754, not offering it into evidence because it's illustrative. I'm just wondering, does that go into EVIS for the clarity of the record if someone's reading the transcript, or how is that handled?
I believe it will be shown in EFIS as
Okay. That was my only question.
for that purpose. 800, which is for Renew Missouri, is own rebuttal. Any objection? It will be received. School Boards Association, 850 is Urban Direct. 851 is Urban Surrey rebuttal. 852 is Vugsden, I hope I got that right, Surrey rebuttal. And those will be all for the gas cases. Any objection to the receipt? Hearing none, they are received. And I believe that's everything. One more thing I wanted to mention while we're still on the record. The commission is looking at having an on-the-record presentation regarding the stipulations for next Wednesday, the 15th, and looking at 10:45 a.m. So it'll be after agenda. I'll be issuing an order subsequently that will give the details of that. Anything else we need to take up while we're on the record? Well, thank you then, and then after reading all those testimony, I'm very glad you were able to work it out and settle a lot of these issues. And with that, we are adjourned. Thank you.
Thank you.